All right, I open then the hearing for day 2. As confirmed prior to the going on record, there are no procedural matters, so we can move on to the examination of Mr. Jacobson.
Mr. President. Yes, yeah. Mr. President, on behalf of the claimants, I'd like to turn to Mr. Molina to present our first witness.
Thank you, Mr. Molina. So I will first do the introduction, and then you can move on to the direct. Yeah. All right. Let's see.
Thank you, Mr. President.
Yeah, Mr. Jacobson, can you see and hear me? The compound question.
Yes, Mr. President, I can both see and hear you.
Thank you. Mr. Jacobson, can you please state your full name for the record?
My name is Michael Jacobson.
Mr. Jacobson, you appear as a witness for the claimants. If any questions are unclear to you, either because of language or for any other reason, please do seek a clarification, because if you don't do so, the tribunal assumes that you have understood the question, that your answer responds to the question.
I understand.
And Mr. Jacobson, you will appreciate that testifying, be it before a court or arbitral tribunal, is a very serious matter. In that connection, the tribunal expects you to give the declaration, the text of which will now be shown on the screen.
Yes, would you like me to read it?
Yes, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Jacobson. Now, since it's a virtual hearing, I have to ask you a couple of additional confirmations. Could you confirm that you're alone in the room?
Yes. Would you like me to pan the camera?
Oh, you're already 2 questions ahead of me. Yes, please. Could you please scan the room?
Yep. Best not to, whoops, knock anything over. There's that edge.
Thank you.
Sit down. I will try to make sure that I'm back in the camera.
Oh, yeah, in the camera. Okay. Thank you. Now, if any time anybody enters the room, please alert the tribunal of this fact and refrain from testifying further until that person has left the room.
Yes.
Then would you confirm that the location from which you are now testifying?
I'm sorry?
Could you please confirm the location from where you're testifying?
I'm testifying from a room in the Baker Hostetler office in Washington, D.C.
Thank you. All right. Do you have any portable device, telephone?
No, I have taken all those are in a different room.
Okay, thank you. Then could you please go to your witness statement? You have 2 witness statements. And I understand you have a hard copy of you in front of you?
Yes, I do.
And could you go to your witness statement of 14 September 2020?
Yes.
You go to the last page.
Yes.
And the page, that is page.
The page with the signature and date.
Yeah, it's 32, isn't it? Could you please confirm that the signature appearing above your name is your signature?
Yes, it is.
Could you then go to your second witness statement of 20 July 2021?
Yes.
And you go to page 32.
Yes.
And confirm for the record that the signature appearing above your name is your signature?
Yes.
Is there any correction, modification, or amendment you wish to make to either witness statement?
No, I stand by my witness statements.
Thank you, Mr. Jacobson. Now, Mr. Molina will ask you a number of questions in direct examination. Mr. Molina, please proceed.
Thank you, Mr. President. Good morning, Mr. Jacobson. Can you briefly tell us a little bit about your professional background?
Sure. I'm a lawyer. I was about 17 years in private practice helping my clients to raise money and do merger and acquisition transactions. After that, I joined a, at that time, small e-commerce company called eBay as their general counsel. I was at eBay for 17 years as well. By the time I left, the group that I was head of had 400 legal and government relation professionals. At the time, eBay split into its e-commerce and payment halves. As I said, I left and I have been semi-retired since, although I am still of counsel at the law firm of Cooley LLP.
And what made you become an investor in renewable energy projects?
I have a firm belief that the problems of global warming are going to be the most significant problems for the entire world for the next 50 and 100 years. I thought that this was a good way to try to ameliorate those problems.
And could you tell us a little bit about your investment in social initiatives in Peru during and even after the project?
Sure. One of the ancillary benefits of the project site that we chose is that it enabled our team to provide, significant benefits to a relatively impoverished area in southern Peru. So we did a long list of projects, including drinking water, sewage, agricultural improvements for first Io and then a little bit further up the valley in Dagua. That is a very direct and easy to see positive contribution to that area.
And what were the government-backed incentives that induced you to invest in the Mamacocha project?
When we were trying to decide where we would potentially build a project, we looked at a variety of things. Peru was extremely attractive because it had a stable, investor-friendly government and had had one for a while by the late 2010s. It had entered into the TPA with the United States, so we knew that there was an investor-friendly backup there. And the RER law was very investor-friendly and made it feasible to invest in small hydro projects because with the guaranteed returns, one could raise financing.
And what is your reaction to Peru's position in this case that you assumed all risks related to achieving commercial operation, including the risk of government interference?
Incredulity. It is simply inconsistent with the laws as I understood them at the time. And it was certainly not noticed in that way at any point while we were looking at the third auction.
Would you have invested if you had any reason to believe that you had assumed such risks?
No one will invest in a project if the counterparty can with impunity breach and you have no recourse. That makes no sense.
So what was your understanding of the restrictions in the contract about extending the commercial operation and termination dates?
Well, my understanding, given that those changes were made in response to earlier concessionaires who had made force majeure claims that may or may not have been strong, and as a result delayed their projects, was that those dates might be immutable in the event of force majeure, but certainly not in the event of counterparty action.
And when your project faced permitting delays in the early years, why did you keep investing?
I kept investing because both those delays appeared to be within the scan of what we anticipated, and because I knew that if they became excessive, we had recourse to the central government and could get recompense.
And when you received Addenda 1 and 2, how did that affect the project?
Well, receiving those addendum were consistent with our expectations, and certainly when we received Addendum 2, that kickstarted the project. We had been talking with both DEG and Intergex for a while at that point, but they were waiting on an extension that would allow us to construct the project before bearing down and finalizing all of the documents as soon as we got that amendment number 2. That's exactly what started happening.
And how did the RGA lawsuit affect those negotiations with Intergex and the bank?
Well, after a period of confusion, because remember, the RGA lawsuit was not initially accepted by the court. So while we knew a lawsuit had been brought, we did not know exactly what it said or what was being sought. But after a period of 4 or 5 weeks of confusion until the lawsuit was available for us to see and for DEG and Intergex to see, it completely killed the negotiations because it made the project untenable until fixed.
And then you sought a suspension. So let me ask, why did you seek a suspension instead of just going to arbitration at that moment?
Because I really wanted to build a project. All of the underlying positives associated with the project were still there. We just had to overcome the political opposition. I did have the choice of, calling it quits and seeking recompense legally, but I was hopeful that we would be able to overcome the local opposition with the help of the central authorities and with the special commission, which I had heard had been successful in other projects in resolving these kinds of situations.
And what is your reaction to Peru's position in this case that the suspension was never intended to result in an extension to the contract dates?
It doesn't make any sense to me. I do not understand why, putting aside the time and large amounts of money that I was spending during the suspension period, why Peru would spend probably hundreds of hours of time pursuing a solution if at the end of that period the project would be impossible to complete and we would just be in a litigation situation. It made no sense.
As the suspension period dragged on to 2018, why did you keep investing in the project? Because
we thought and were encouraged to think that we would get to a positive solution eventually through our communications with both MINEM and the Special Commission.
And what was your reaction when MINEM denied the third extension request?
I was crushed. first of all, it was a complete 180-degree reversal from where we thought things had been just a couple of weeks before. It was clear that it put the final stake into the body of the project. The project was ended. I was very sad because I thought it was going to be a good thing for the region, for Peru as a whole, and for the world. And I was, quite frankly, a bit angry because this kind of abrupt about face in a couple of weeks is not something that is normal.
I have no further questions. Thank you.
Thank you, Mr. Molina. Mr. Granet, who is conducting the cross-examination? Mr. De Rosa?
Yes, Mr. President, it'll be me.
Okay, Mr. De Rosa, please proceed.
Thank you very much. Good morning, Mr. Jacobson.
Morning, Mr. De Rosa.
I will be conducting your cross-examination this morning, and the only request that I would make is that you wait until I complete my questions before you answer, just to facilitate the task of the interpreters and the court reporters. I will be showing you some documents on the screen for everyone's convenience, but I do understand you have the capability to pull up documents as necessary. Is that a correct assumption?
I have not set up my computer to do that, but I can.
Okay. Well, let's see how it goes. We'll show you things on the screen, and if you have a question or you need to see more context, you will let us know, or perhaps our opposing counsel could show you the document on redirect as necessary. Would that work?
Yes.
Okay. So you were the founder and member of Latam Hydro LLC, correct?
Yes.
And you founded that company in 2014, correct?
Yes, I believe that's the case. That's the company that became Mamacocha.
And you also formed a company called Reinvest Management Limited, correct?
That's correct.
And you were the sole owner of that company, correct?
For a period. I'm going to actually refer to my first witness statement, which has the corporate structure, because as you know, the structure is a little complex.
You said this in paragraph 3 of your first witness statement. You are this, it says you're the sole owner of Reinvest. Do you see that?
Oh, yes, I was.
Okay. And that company was founded in 2008. Is that consistent with your recollection?
Yes.
At all relevant times for purposes of this arbitration, you owned and controlled CH Mamacocha, which I shall refer to as CHM, either directly or indirectly through Reinvest or Latam Hydro. Is that right?
That's right. Although after 2014, my co-investor, Gary Bengier, was a 50% partner, so we have to agree on matters going forward.
Before the renewable energy investment in Peru that is the subject of this arbitration, you had never before invested in Peru, is that correct?
Mr. I hate to interrupt, but here I have to ask a question about numbers.
Yes.
Mr. Jacobson, can you please go to page 29 of your witness statement? Actually 28. Because you said as of 2016, you just testified was a 50-50 with Mr. Bengier and you, right?
Yes, that happened in 2014, I believe.
2014, then the top of page 29, which reflects the situation from May 14 to December 2016, it says 72-28. See that?
You're entirely correct. When we initially set up when Gary initially made his investment, we had agreed on a different allocation. As time went on, we adjusted that to the 50-50.
Right, so the adjustment is in 2016, because if you go to page 29 at the bottom and page 30, you see 50-50.
Yes, correct.
And
yes.
The next one, you see also the next to June 17. You see that?
Yes, that's correct.
But if you go then to paragraph 58 of your witness statement, sorry, Mr. De Rosa, that's simply to get the numbers right.
No problem, Mr. President.
Okay, so you see there in June 2017, Mr. Benjier, if I pronounced it correctly, he walked away.
He told me he was no longer going to put in the 50%, so we had to adjust the terms of the agreement. We did not change the underlying ownership.
Okay.
But essentially, I get the money that I have spent since that date back first.
Okay, thank you. Okay, that's it. So, thank you, Mr. De Rosa. Please continue with your cross.
Thank you, Mr. President. So I'll reread the question that I had posed to you before, which was, before the renewable energy investment in Peru that is the subject of this arbitration, you had never before invested in Peru. Is that correct?
That is correct.
Before you invested in Peru, had you ever invested anywhere else in Latin America?
No.
Do you speak Spanish, Mr. Jacobson?
No.
Before your investment in Peru, had you ever invested in a project that required obtaining government concessions?
I'm sorry, could you repeat the question?
Sure. Before your investment in Peru, had you ever invested in a project that required obtaining government concessions?
Yes, the Eastern European renewable energy projects required government permits and government concessions.
You are not yourself an expert in renewable energy, though, is that correct?
That's correct.
In fact, in your first witness statement in paragraph 3, you say, quote, "At all times, my role was limited to owning and financing these companies and their projects. I relied on experts from the renewable energy sector to oversee the development, construction, and operation of the projects." Do you recall saying that?
Yes, I'm an investor. I oversee my investments, but the statement is correct.
So to make the investment in Peru, you relied heavily on advisors and consultants, correct?
Advisors, consultants, and employees, that's correct.
And that included Peruvian lawyers, correct?
That's correct.
And it also included technical consultants in Peru in the energy sector. Is that right?
That's correct.
When you first started focusing on the possible project in Peru, you were aware that there had already been 2 RER auctions. Is that right?
Yes.
The RER auction that you ended up participating in was the 3rd auction, correct?
That's correct.
And at the time that you were considering bidding in the 3rd auction, you were aware that there had been certain problems with the first 2 auctions, correct?
Yes, I understood that some concessionaires in the first 2 auctions had not been diligent in pushing their projects forward and had made weak claims of force majeure, which gave them the ability to delay their projects.
If I could ask my colleague to pull up your first witness statement, paragraph 17, please. You see the part that starts with "we knew." the second sentence?
Yes.
All right, so in this sentence, and I'm going to just read it, it says, we knew the projects from the first two public auctions had experienced delays attributable to the concessionaires, some of which had no prior experience or were intending strictly to flip the project after winning the auction. Do you see that?
Yes.
So in this paragraph, you are identifying two different problems, one of which you just mentioned before I asked this question, or before we read this statement. And that was the problem of the delays attributable to the concessionaires, correct? And the other problem that you mentioned here was that some winning bidders were what you call flipping their projects. By that, are you referring to the fact that some winning bidders were just turning around and selling their project to third parties, leaving it to those third parties to construct the power plants?
My understanding is that some winning bidders were not proceeding diligently towards construction, but instead were hoping, once they had received the RER, the RER contract, to simply sell their rights under that contract. In whether in some cases well before construction.
All right, let's pull up paragraph 15 of Mr. Jacobson's first witness statement. And here, you say at the beginning of the paragraph, quote, from the outset, our plan was first to develop the Mamacocha project and then sell a majority stake to a company that would oversee the project's construction and operation phases. My team would then pivot to developing the upstream projects, close quote. Do you see that?
Yes.
All right, and can we pull up, please, exhibit R0175. This is an email from you to various Intergex representatives, right? And we're going to highlight for you a part here that says, you see the sentence there in the middle, the easiest way to do this would be for us to sell the entire project to you, close quote.
Mr. President, I'm so sorry to interrupt. Is it possible for the witness to have a chance to read the document that has just been put on the screen before he answers a question?
Sure.
Yeah, let me ask you. Mr. Jacobson, when
yes.
a document is shown to you and you are not certain or or you need to refresh your memory, please ask Mr. De Rosa to some time to review the document.
Sure, we can scroll back and forth if you wish, Mr. Jacobson.
Why don't you just scroll up to the beginning? Okay, this is I believe the date at the very top is incorrect, as the email header shows. It's January 22nd, 2018. Yes, go on. Scroll down.
Let's scroll down all the way to the part that we are asking Mr. Jacobson about. Thanks.
Yeah, Mr. Rosa, wait a moment. Mr. Jacobson, have you had the opportunity to review?
Yes, I think I'm comfortable.
Okay, right. Okay.
That's what I understood as well. If it's not the case, Mr. Jacobson, just feel free to interrupt and say you want to review more, or you want to review a different part of the document. I guess my question is, isn't it the case that it was your intention essentially to flip the project to be able to focus on the upstream projects?
No, it was our intention to partner with a a larger, more capital rich firm to develop the project. And that would also enable us to give our personnel the time to do the development work on the upstream projects.
Yeah, but here,
obviously by 2018, as this letter indicates, circumstances changed. We had the RGA lawsuit and the long delays in trying to resolve the situation. As I indicated, I was hopeful that things would move forward, and I was reconnecting with Energex. Unfortunately, as you know, the Energex response was very negative.
right, but you were in fact trying to, at that point, to sell the entire project, is that right?
By 2018, the project, which was in distress, there's no question we had changed our strategy, and as indicated in the lines immediately above those that you have highlighted, we had changed our strategy, and we're seeking to sell the entire project.
Thank you. The design of your project was done by you and your team of consultants and advisors, correct?
Well, it was done by the team. The team obviously hired very expert engineering firms and others to help with design.
Right, and there was no government agency or entity involved in any way in the design of your project, was there?
That is correct.
And the location of your project also was selected by you and your team, as you put it. Is that correct?
That's correct.
And no government agency or entity was involved in any way in the selection of your project, is that correct?
The selection of the project site, that is correct.
Once you decided to submit a bid in the third auction, your team prepared the relevant papers for the bid, describing the location and the technical characteristics of your proposed project, correct?
Yes, I believe that is the case. They prepared all of the documentation necessary to make a successful bid.
And there was no government agency or entity involved in any way in the preparation of your bid or of your bid papers, correct?
That's my understanding, yes.
You were aware at the time that you were preparing your bid for the third auction that the auction was for the fixed 20-year tariff rather than for a government concession to generate energy. Is that right?
That's correct. I understood they were. It had been explained to me that they were two different things that we needed as part of the permitting process, the development process, to first get the environmental and other permissions that would then be rolled up into the concession, the request for a concession.
So the concession to generate energy was a separate and different concession that you had to obtain, called the final concession or concesión definitiva. Is that your recollection?
That is my understanding, yes.
The final concession enables a power generator to produce and sell electricity even without an RER contract. Is that correct?
That is correct.
And this is true regardless of whether the final concession was obtained before or after the RER contract was signed, correct?
That is correct, and it's true if the electricity producer is large and not subject to the RER regime, or small.
You selected as the location of your project the Mamacocha Lagoon in the region of Arequipa, correct?
Yes.
Were you aware at the time that you selected the Mamacocha Lagoon as the location for your project that it was one of the world's largest spring lagoons, if not the largest spring lagoon?
I was aware that it had unusual hydrology, that it was that the waters from the valley above had gone into permeable soil, so there was in fact no river that sourced the lagoon, but at the lagoon and indeed along the Mamacocha River. Starting almost immediately below the lagoon, there were very substantial springs where the water essentially came back above the surface and eventually went down to the Cocha River.
Are you aware that a few years ago, the plenary of the Andean community formally declared the Mamacocha Lagoon a natural wonder in recognition of its biodiversity and its overall ecological and environmental importance?
Had
you heard that?
I don't believe I had heard that, and I'm not sure when you say a few years ago whether you're referring to
2019 specifically.
Yeah. Yes, at that point, I'm afraid the project had stopped, and I may have missed the activity.
I'm sorry to interrupt. Is there a foundation for the question? And if there was, I'm sorry if you explained it already, Mr. DeRosa, but I just didn't hear what the foundation was for that fact that you just read.
I don't have to establish a foundation as such. I have to ask him questions related to his witness statement. He said in his witness statement that he's concerned about the environment, about global warming, et cetera. And so these questions are related to that.
I just want to understand.
Mr. Molina, 1 second. Mr. DeRosa, the reference to a natural wonder is somewhere in the record, if my memory serves me right.
In Exhibit R0095, Mr. President.
Thank you for helping me. The declaration by the Andean community, that's
yes.
The same? Yeah, okay. Right, there's foundation. You can proceed.
Thank you, Mr. President.
Let's pull up clause 3.3 of the concession contract. This is, for the record, C0002 at page 39. In the English version, and we're going to use the English version, this is a translation that was provided by the claimants. We don't accept the accuracy of all of it necessarily, but we will use it for present purposes.
Yes, and when you say the concession contract, why don't you go back up to the heading? So I have two questions. First, this is the what I believe you referred to as the RER contract, the contract between the government and CHM with respect to the providing power. And this is our contract as opposed to anybody else's?
Yeah, this is your specific contract, correct?
Thank you.
So the first sentence there in 3.3, if you can see it, it says, the concessionaire company shall design, provide the financing, and supply the goods and services required to build, operate, and maintain the power generation plant specified in Annex 1. Do you see that?
Yes.
Would you agree that by signing the RER contract, you fully assume the financial risk of the project?
We fully assumed the financial risk of the project, but we did not assume the risk that our counterparty would blow up the project.
Right, those are different issues. We obviously dispute that last part, but I'm asking you about the financing specifically now, Mr. Jacobson. So you do agree that you assumed fully the financial risk of the project? that correct?
I reiterate my comment.
Let's look at RER contract section 6.4 on page 42 of exhibit C0002. And 6.41 here, the contract refers to different ways to finance the project, correct?
Yes, and this is entirely consistent with the overall RER law, which was intended to make these small hydro projects financeable so that one could get non-recourse financing.
Well, let me just look at the transcript here for a second. So that one could get non-recourse financing. Do you see that anywhere in the, is that anywhere in the contract?
No, but exactly this kind of pledging, mortgaging, and the like is what one does when one is engaged in working with a bank that is going to provide non-recourse financing, because the bank wants to know that should something go wrong and it have to seize the, that it has assets to back up its the money, or to back up the money that it has loaned to you on a non-recourse basis.
We'll come back to that, Mr. Jacobson. Let me focus your attention on 6.4.2. Now, the clause immediately below the one we just saw. This one says, quote, "The provisions in the foregoing paragraph shall not release the concessionaire company from its obligation to comply with all of the provisions set forth herein in the final concession contract and in the applicable laws," correct? Close quote.
That is correct.
So essentially, the form of financing that you selected would not in any way alter your other obligations under the contract. Is that your interpretation as well?
I think that is a fair inference from the provision.
In paragraph 18 of your second witness statement, you admitted, quote, "The RER contract did not constrain our choice in which financial approach we might decide to take," close quote.
That is correct, but the RER contract, in accordance with our expert, Mr. Whalen, was very specifically designed to make non-recourse financing from both commercial and development banks easy and possible.
Neither the bidding rules nor the RER contract nor any other norm or government directive required that you use project finance as the financing mechanism for the project. Is that a correct statement?
That is correct, but those other forms of financing had historically not resulted in small hydro projects, and that was why the RER law back in 2008 was created and extended to small hydro projects, if you go back and look at that.
The RER regime required you to submit a work schedule with the main milestones of the project. Is that right?
That is correct.
And that work schedule had to be approved by the Peruvian authorities, and specifically the ICSID. Do you recall that?
That is correct.
One of those milestones in the work schedule was the financial closing date, correct?
That is correct.
So your contractual obligation was not either to use project finance or not use project finance. It was rather simply to reach financial closing by the date established in your work schedule. Isn't that right?
That is correct.
That means that if it was impossible for you to meet the conditions imposed by your lenders, your contractual obligation was to find a different way to reach financial closing by the contractual deadline. Is that correct?
That's correct.
But you picked project finance for the reasons that you explained, and you stuck with it to the bitter end. And let me pull up paragraph 8 of your second witness statement, Mr. Jacobson. And here it says, quote, except in very rare exceptions, the construction of renewable energy projects is financed primarily through non-recourse project financing loans. Financing these projects through other mechanisms is simply not as profitable and subjects the project developer to greater penalties in the event the project underperforms, close quote. Do you see that?
Yes.
And this sentence here, financing these projects through other mechanisms is simply not as profitable, implies that you did, in fact, have alternative mechanisms. They just weren't as profitable. Is that right?
As I said earlier, these projects were simply not being built. It was not a matter that they were less profitable. It was a matter that they were not profitable at all, and therefore no one would build them.
In your first witness statement, you stated, quote, from 2012 to 2013, my team conducted extensive legal due diligence on the RER promotion.
Yes.
Close quote.
Yes.
You indicated that you took legal counsel from Santibáñez Abogados, which is a law firm in Peru, correct?
A very well-respected firm that had particular expertise in the energy sector, yes.
Was there any other Peruvian law firm or lawyer advising you at the time? That you can recall?
I don't recall any other lawyers.
In part to address the problems in the first two auctions that we just discussed a while ago, in 2013, the government promulgated a Supreme decree that amended the RER regulations. Is that a fair statement?
That's my understanding.
And that Supreme decree was one of the issues on which the Santibáñez law firm had advised you in 2013, correct?
Yes.
Let me direct your attention then to your first witness statement, paragraph 17, Mr. Jacobson, the third sentence specifically. And if we could pull that up, please.
The third sentence, I learned that many of these...
Can we highlight the third sentence, please, where it starts with, sorry.
I learned
that, yeah. Thank you. All right, so here you say, quote, I learned that many of these concessionaires extended their milestone deadlines using vague force majeure arguments. For that reason, we were not surprised when Peru enacted Supreme Decree number 24, and then it goes on to say the date in July 2013, months before the third auction, making it more difficult for concessionaires in the third auction to extend the commercial operation deadline and concession term. And then you go on to say for delays attributable solely to the concessionaire or for force majeure delays beyond the control of both parties. Close quote. Do you see that?
Yes.
Now, as we just discussed, the third auction that you mentioned here is the one that you participated in, correct?
Yes.
The bidding rules for that auction were published by the government in advance of the auction, right?
Yes.
And all bidders were required to abide by the bidding rules, correct?
Yes.
The bidding rules included as an attachment the text of the RER contract that would be signed, correct?
I believe that's the case, yes.
Prior to your decision to submit a bid in the third auction, your advisors in Peru informed you about the bidding rules, correct?
Yes.
And they also informed you about the RER contract text that was appended to the bidding rules. Do you recall that?
Yes.
Did you personally review the RER contract and the bidding rules?
No, not at that time.
Let's take a look at the document Exhibit R0153 from the record. This is an email sent by a person named Lizzie Benzaken. Do you see that? Lizzie
Benzaken. She's, yeah, you have her witness statements.
Yes. And Ms. Benzaken was one of the lawyers of the Peruvian law firm you had engaged, Santibáñez Abogados, correct?
Yes.
The email was addressed to Stefan Sillen and Andres Bartrina, sorry.
Correct.
At that time, Mr. Sillen was president and CEO of Reinvest, and then subsequently Hidroeléctrica Laguna Azul, is that right?
Yes.
And Hidroeléctrica Laguna Azul was the predecessor entity of CHM, correct?
Yes.
So the name of the company was changed from Hidroeléctrica Laguna Azul to CH Mamacocha in 2017, right?
That sounds right.
And Mr. Bartrina, for his part at that time, was the project manager and technical consultant at Reinvest and subsequently at Hidroeléctrica Laguna Azul, correct?
Yes, I believe so.
To simplify for our present purposes, we'll just refer to both Laguna Azul and CHM as CHM, if you don't object. This email from Ms. Benzaken is dated August 19, 2013. That was before you submitted your bid in the third auction, correct?
That's correct.
You submitted your bid in the auction later in 2013, right?
That's correct.
And this email was a report from your lawyers to your country team on the bidding rules for the third auction. Is that correct?
I believe it was a translation and summary. We had subsequent discussions about the rules, but yes.
At that time, the bidding rules had just been released to the public, right?
As far as I know.
Let's go to page 3 of this document, in the top of the page specifically. You see the heading there, it says, quote, highlights conditions of the third auction RER, quote, close quote. Do you see that?
Yes.
At the bottom of the same page under the subheading qualification envelope hyphen envelope number 2, it provides a list of the documents that the bidders were required to submit with their bid. Do you see that?
Yes.
And the list continues on to the next page, page 4. And do you see the entry in the third bullet point or tick from the top, starting with the words express recognition?
Yes.
Yeah. And that entry says, quote, express recognition of unchangeable character of the termination date of the contract, even when there are events of force majeure, close quote.
Yes.
Now, this email wasn't addressed to you, but did you see this email at the time? Was it forwarded?
I don't recall, but it was discussed, and we did understand that in the events of force majeure, which was, not the fault of either party, that there would be issues in getting an extension of the termination date, but it said absolutely nothing about our counterparty taking actions and having, that situation was just not covered.
Let's go down to page 6 of the same document. You see paragraph, specifically, let's go to paragraph 3.1, starting with the words, quote, the most important. You see that? That says the most important characteristics of the contractual regime applicable to RER projects, et cetera, it says are as follows. The first item that it mentions is the reference COS date, which shall be no later than December 31st, 2016. And there's a part there in point 3.1b that starts with if it is the case. You see that part? Let's highlight it if we can. There it says, quote, if it is the case that the real date of commercial operation has not been achieved, then the contract shall be automatically terminated and the guarantee for faithful completion shall be required, close quote. You were aware of this requirement at the time, right?
I had a general awareness, but obviously it was going to be dependent on the reasons why the real date of commercial operation had not been achieved. And in fact, in our contract, the COS date was extended.
The next paragraph expressly refers to the contract term and still in the same section 3.1, it says, quote, the contract term date will not be changed for any reason, even by force majeure, and is scheduled for December 31st, 2036, close quote.
That's correct. And they, again, spelled out force majeure.
I haven't asked my question yet, Mr. Jacobson. So your counsel had alerted you before you made the bid in the third auction to all of these provisions in the bidding terms in the RAR contract. That's right, isn't it?
Yes.
In connection with your bid, your team submitted to the government 2 sworn statements. Those declarations, both of which were signed in October 2013, are at exhibits R0138 and R0139 in the record. Are you familiar with the sworn statements that I'm referring to? We will put one of them on the screen in a moment.
I did not see them at the time. I have seen them since. They're, of course, in Spanish, which I do not read. But feel free to put them on the screen and ask questions.
We'll see how it goes. Neither of these sworn statements has an English translation, so let's just focus on the one at exhibit R0138, which consists of a single sentence, and maybe we can rely on the help of our interpreter. So this statement was signed on behalf of CHM by Mr. Carlos Diaz-Canseco, correct?
Yes.
And who was Mr. Diaz-Canseco?
Mr. Diaz-Canseco was one of our employees. He was in charge of, among other things, relationships with the government and relationships with the communities.
Let's review the statement on the screen. It's the whole declaration consists of a single sentence that appears on the screen now. I will read it in Spanish, and hopefully our interpreter can assist us. I'm not sure how this works, or maybe an easier way to do it would be for me just to translate it, and your counsel can object if it's not quite right. Let's do that just in the interest of time and to avoid the hassle. So it says here, we declare under oath that we recognize the non-modifiable character of the date of termination of the contract, even when there are events of force majeure. So here, CHM was formally acknowledging under oath that the termination date could not be modified even in the face of force majeure events, correct?
Yes, but again, it says nothing about acts of our counterparty.
Right. Yeah, I understand your position as well. You mentioned in your second witness statement the amparo proceeding. That was a judicial proceeding in Peru that was started by a private citizen, correct?
Mr. De Rosa, I think you now move to the next subject.
Yes.
Amparo proceeding. Is that a good moment to break for 15 minutes?
Oh, sure. Absolutely, Mr. President.
Okay. Mr. Jacobson, you are under testimony. I hope that you know what it means. It means that you are not allowed to communicate with anyone about this case during your testimony, but you are free to go for a natural break, if I may call it that way.
I understand. I will stop my ears and my mouth.
Okay, good. Right, but feel free to take a coffee or something. Then 15 minutes break until 16:45 CET, sorry.
Thank you, Mr.
Right, right, I see, yeah, everybody's back. Right, Mr. Di Rosa, please continue the cross-examination.
Thank you, Mr. President. Mr. Jacobson, I'm just going to restart the segment that we were talking about when we went on break. I was mentioning to you that you discussed in your second witness statement, specifically in paragraph 28, the issue of the amparo proceeding. And my question that I had posed initially was, that was a judicial proceeding in Peru that was started by a private citizen. Is that your understanding?
That's correct.
And that proceeding concerned the challenge to CHM's environmental permits. Is that right?
That is correct. In the Constitutional Court.
Right. That's the amparo proceeding. In your pleadings, your counsel totally dismissed the importance of the amparo proceeding. For example, the reply at paragraph 104 referred to it as, quote, background noise, close quote, and as a, quote, nuisance lawsuit, close quote. Do you recall that?
Yes.
And we noted that it was in the opening statement yesterday as well. Now let's pull up exhibit C0247. Now, this is a legal opinion that was sent by the Peruvian law firm CMS Grau to your potential lender, DEG, correct? You see that?
Yes. Studio Grau was the law firm hired by DEG.
And the memo is dated December 21st, 2018. You see that?
Yes.
And this legal memorandum was commissioned from the CMS Grau firm by DEG itself, correct?
Yes, that would make sense.
The purpose of the memo, as indicated in the subject line, was to provide DEG with an analysis of the various pending legal proceedings relating to your project, correct?
Yes, it was essentially update due diligence from the work that Studio Grau had done in 2016 and 2017.
In the first paragraph, the CMS Grau lawyers defined the pending proceedings as the proceedings power plant. And that may have been a translation issue at the time if the original was done in Spanish, but it's clear from the context that the defined term there refers to the proceedings themselves rather than to a particular plant. Now, at the end of the second paragraph in this section, which is captioned Roman numeral 1, background and queries, the memo says that one of its goals is to, quote, determine the consequences and severity of the impact of a negative decision on the implementation of the project, close quote.
Yes.
Do you see that part?
Yes.
Okay, so let's turn now to page 4 of this document. And specifically at point 3.2 at the top, the CMS Grau law firm provided overall considerations and recommendations on the various proceedings, including the amparo proceeding. And the part at the beginning of point 3.2 states, quote, Although the current proceedings power plant, meaning the proceedings, constitute a remote contingency because of the way they are strategized, the consequences could be very serious in case of obtaining an unfavorable resolution or in case the supervisory authority later determines that the environmental management instrument that supports the project does not correspond and has been issued without having in consideration the real impacts of the project, close quote.
I'm sorry to interrupt. I do not believe that Mr. DeRosa has established that Mr. Jacobson is aware or familiar with this document. And at the very minimum, Mr. Jacobson should have an opportunity to read the full document before answering a question about it.
Jacobson, do you have an opportunity to familiarize yourself fully with the document?
I don't believe that I've seen this particular document before. I would be happy to read through it quickly and then answer Mr. DeRosa's questions.
Mr. DeRosa, if you would like to maintain your questions, we should offer Mr. Jacobson an
Sure,
opportunity.
happy to have him review. Do you want to pull it up, Mr. Jacobson? Do you want to just have us scroll through it as you?
Why don't you just scroll through it?
Go through it, okay. If you could just.
Sorry, Mr. DeRosa, can I assume that the document has been presented by claimant because it's C is something. Do you know why? Does claimant or yourself can indicate why is this a draft and not the final report?
We don't know, Mr. Chairman. Mr. Tawila. This was produced in the document production, as I understand it. We didn't receive from them a final version. Perhaps claimant's counsel can clarify
Sure.
why this is only in draft.
Yes, thank you for the question, Professor Tawil. Our understanding is that this was a draft that was shared by Studio Grau to claimants in December in 2018. And the reason why it's a draft and not a final is because the project was terminated by Peru on December 31, 2018. Therefore, mooting the need for CMS Grau to complete its legal diligence on the project.
So formally, this document was never issued. I mean, it's just a draft, right?
It's a draft that, again, was shared by CMS Grau to claimants. That's as much as we know.
Right. Mr. Jacobson, please proceed with reviewing the document.
Thank you. You may scroll.
Mr. DeRosa, can you scroll through?
Yes, we'll do that. Just let us know, Mr. Jacobson, when you're done with a particular segment, and we'll scroll another segment.
Fine.
Mr. President and Mr. DeRosa, would it be easier if Mr. Jacobson had the ability to review the entire document? He said that he has a computer, he could open up the entire document and look at his time.
That would be easier for everyone.
That would be easier, but I have not, I'm not in front of my computer. I am in front of the Baker Hostetler computer, and I'm not sure quite how to do that.
Is there someone, Mr. Reisenfeld, who could go in and help him if he's in your offices? Just pull it up.
Yes, we're having somebody go and make sure that he has access to the document.
All right, thank you.
Thank you. I have someone who's come into the room and dropped off a paper copy of the document. I will now read through it. Thank you.
Yes, please do, Mr. Jacobson, and let us know when you're finished.
Yes, I am ready.
All right, so thank you, Mr. Jacobson. So let's go back to 3.2 and this statement here. And I'll just read the relevant part again. Quote, although the current proceedings constitute a remote contingency because of the way they are strategized, the consequences could be very serious in case of obtaining an unfavorable resolution, or in case the supervisory authority later determines that the environmental management instrument that supports the project does not correspond and has been issued without having in consideration the real impacts of the project, close quote. So here, the Peruvian lawyers were expressing their view that there could, in fact, be very serious consequences if any of these proceedings, including the amparo proceeding, were to be successful, or if your environmental permits were found to have been improperly granted. Isn't that a correct interpretation of this?
The lawyers made two findings. One, that the contingency was remote, in other words, quite unlikely. And in the analysis section, they then described the reasons why it was unlikely, including that that this should be brought as a contentious administrative proceeding rather than as an amparo, and that there was no evidence adduced to the amparo. But it did say, I agree with you, that in the event of that remote contingency, the consequences could be serious.
Right, but the remote contingency, Mr. Jacobson, did in fact become realized, did it not? The amparo the amparo request was accepted, and these very serious consequences did come to pass. Isn't that right?
Long after the project had ended, yes.
Well, let's and in the part immediately below the one we just read in 3.2, it lists some of the possible consequences of these proceedings being successful, and those include reclassification of the project and revocation of the final concession. Do you see that?
Yes, those are serious consequences for a exceptionally unlikely occurrence.
Let's focus for a moment on the document that appears at Exhibit R0177 in the record, which we will pull up on the screen now. This document is dated March 15, 2017, and it's a preliminary issues list for legal due diligence prepared by DEG for CEM. The document reflects certain questions from DEG to CHM and CHM's responses to those questions. Now let's turn to page 3 of this document, and specifically to point 7.
Again, would it be possible for Mr. Jacobson to have a chance to read the document so that he may be able to answer questions?
Yes.
I don't believe I have that, but I'm sure someone. No, but I'm sure someone will bring it to me.
That would be helpful, Mr. Molina, if they could do that again. Just print it and bring it to him.
Yep, we're taking care of it. Thank you, Mr. Dorso.
Thank you. Again, someone else has come in and brought me a document. Just leave it there. Yes, you may continue, Mr. DeRosa.
Right. So let's, we're at point 7 in the section of the document that discusses the amparo proceeding. And do you see there the part that's captioned comment DEG?
Yes.
Would you mind reading in its entirety point A of DEG's comment? Or reading it out loud?
Sure. We understand from Estudio Grau that Santavania Zapagodos S.A. are taking the position that the amparo will be admitted only to the extent that the appeals court considers that there is urgency on the claim. In Estudio Grau's view, however, the amparo could be admitted under other grounds as well, including if the appeals court concludes that there is a risk of permanent damage, which Estudio Grau considers well possible. Please comment.
All right, and then in point B below that, DEG asked you for an estimate of the percentage chances of success of the amparo request, and CHM responded that it was unable to provide a percentage. Do you see that?
Yes.
All right, so
I've never been able to get a litigator to give me a percentage, and I've talked with many about many cases.
rightly so. All right, and so this is a document dated March 15, 2017, in which DEG is saying to you, Estudio Grau thinks the amparo may well be admitted, and it considers that well possible, correct? That's what they're saying.
Yes, although the document that you showed me just a couple of minutes ago, from perhaps a year later, showed that Estudio Grau still at that time considered the possibility of an adverse result to be remote.
Perhaps, but what I'm focusing on here is the concern that DEG was expressing to you about the potential impact of the amparo proceeding. It seems clear from this that DEG did not share the claimant's view that the amparo proceeding was merely background noise, as claimants called it in the memorial. Isn't that a fair inference?
Whatever DEG thought, it certainly wasn't interrupting their work towards getting us to signing documents and eventually to financial close.
Let me ask you a couple of questions about the ruling that was issued in the amparo proceeding. I'll call that the amparo ruling. For the record, the Spanish original of that document is at exhibit R0070, and the English translation is at C0305. We don't need to put it on the screen, at least for now. Mr. Jacobson, I know you're not a Peruvian licensed lawyer, but based on reports from your Peruvian lawyers, was it your understanding then, or is it now, that the Amparo ruling annulled the claimant's environmental permits?
Well, after the appeal was denied, yes, the environmental permits were annulled. But as you know, one of the considerations of the court was in considering what I would call the balancing of the equities. I'm sure that's not what it's called in Peru. They looked at the project, which was suspended and it was dead, and balanced the potential damage there against the damage of issuing the ruling. So the ruling, the ruling was impacted by the fact that the project had already been killed by the measures.
All right, so I do see that you say, yes, the environmental permits were annulled as a result of this. And that ruling, the Amparo ruling, also invalidated claimant's final concession. Isn't that true?
My understanding is that because the final concession was dependent on the environmental rulings, it could not stand if the initial environmental permits could not stand.
Right. And are you aware that in this arbitration, the claimants are not challenging either the validity or propriety of the Amparo ruling or of any of the judicial proceedings related to it?
None of those measures, none of those matters are part of the measures. That is correct.
This Amparo request, as far as you can recall, was in fact filed before the RGA lawsuit. Is that not true?
I understand it was originally filed in 2016, yes.
The various documents that we've been talking about from CMS Grau and DEG, had your lawyers ever shown those to you? Were you familiar with the more recent one that we talked about, the one where DEG was asking you questions about the Amparo proceeding? Had you seen that document before?
I certainly didn't see it at the time, and because we were in the midst of the quick changeover of the Peruvian position, and I do not believe I reviewed it as part of my review for this cross-examination.
Right, but you were the project owner, so it's perhaps surprising that they didn't provide you these documents at the time. Let's turn to a different subject, Mr. Jacobson. As we discussed, the place that you selected for the project in Peru was the Mamacocha Lagoon. Initially, the relevant environmental authorities concluded that your project would in fact have a significant environmental impact, and that's why they classified it as a Category 3 project. Is that consistent with your recollection?
No, because we asked, and the explanation we were given at the time was that the project had been classified as a Category 3 project because because ARMA, the regional environmental authority, only had the authority to rule on permits up to for hydropower projects up to 20 megawatts. And because this was a 20 megawatt project and therefore the largest possible project it could rule on, it assumed that that would make it a Category 3. We obviously disagreed with that analysis and asked for reconsideration. The ARMA then actually sent a technician up to look at the project. After that, the ARMA agreed that reconsideration was appropriate, but again, it did not issue a permit of any sort at that point. It went through a thorough legal and technical analysis that consumed about 6 months at that point before coming back to us in September 2014 and confirming that it had accepted the DIA.
A Category 3 project is one that has a significant environmental impact, correct? I mean, that's what that means.
Right. Typically goes to projects that involve dams that cover forests or require people to move, or mining concessions that emit toxic chemicals and the like, as I believe the witness statement of Mr. Chavez has said that the small run-of-the-river projects are rarely, if ever, receive a Category 3 designation.
The Category 3 designation occurred in October of 2013. Mr. Sillen says in paragraph 71 of his first witness statement there was 14 October 2013. Does that sound about right to you?
Yes, that sounds about right. 2014 or 2013.
Yeah, there's a document C0185 on page 1 that also says it's October 2013, but there's a discrepancy in the specific date.
I believe it was October 2013 because we received word of the reconsideration just before we signed the concession. And we signed the concession, as you saw, in February 2014.
So October 13th, then October 2013 is when the Category 3 classification was assigned to your project.
Yes. And as I said, we received word that that the reconsideration that the project was that the Category 3 designation was going to be reconsidered in February of 2014, and then we received the final approval of the DIA in September of 2014.
Now, the real COS deadline in your RER contract was 31 December 2018. Is that consistent?
Well, it was amended, as you know, by addendum number 2 to become March 20.
I'm talking about the original one. Yeah, the one that you had in October 2013. At that point, your real COS deadline was 31 October 2018. Is that right?
If you could please let Mr. Jacobson finish the answer. I think he was interrupted. Please.
No, in 2013, the contract had not yet been amended, and so the real COS date was the December 31, 2018.
Right. So that meant that at the time of the Category 3 classification, you still had more than 5 years before the real COS deadline, right? Between 2013 and 2018, there were 5 years.
Yes.
But as you just mentioned, your team appealed the Category 3 classification and managed to get the authorities to change the classification of the project from Category 3 to Category 1, correct?
That is correct. When we discovered that the reason for receiving such an unusual designation had nothing to do with a technical analysis of the environmental issues associated with the project. We thought it was absolutely appropriate to request a reconsideration, which, as you know, was successful once those technical evaluations were made.
Well, temporarily successful, right, until the Amparo ruling. But in any event, you filed that appeal because you believed that your project in the Mamacocha Lagoon was going to have only a slight environmental impact. I think your counsel used the term minimal environmental impact.
Yes,
is that right?
That is the nature of run-of-the-river, small run-of-the-river projects. They tend to have relatively little environmental impact, and that's particularly the case in the dry volcanic area that our project was located in.
And so it was because your perception was that the impact on the environment would be minimal. That's why you thought you only needed to submit to the government authorities a declaration of environmental impact, or DIA, correct? That was the
yes, as was consistent with almost every small run-of-the-river project granted permits in Peru. We had expected to receive a Category 1 designation. We were astonished to get the Category 3. And when we found out the reasoning, we thought it was absolutely appropriate to correct the mistake that the ARMA had made, because this was a relatively new process for them.
So a Category 1 designation means that one needs to present a DIA, which is the type of assessment that was required for projects with only a slight or minimal environmental impact. Is that right?
That's correct.
And in the end, that was in fact the type of assessment that you filed a DIA. Is that correct?
Yes. Well, we filed. Well, yes. Once the ARMA had done its technical assessment and indicated that we should file a DIA, we filed one. They did the appropriate analyses and ultimately issued the permit.
All right. So your environmental permits were approved on the basis of that DIA, correct?
Well, yes, that was our environmental permit.
Right.
I believe, and I'm sorry to interrupt. I believe that was a mischaracterization. I believe Mr. Jacobson testified. We can go back to the record that it was approved based on analyses and technical assessments made by ARMA, not on the basis of.
Sorry.
You can't testify for Mr. Jacobson. Mr. Sorry.
Mr. Rosa, could you please repeat the question, and Mr. Jacobson, can you please repeat the answer?
And your environmental permits were approved on the basis of the DIA that you submitted, correct?
Our environmental permits were approved on the basis of the analyses that ARMA performed after we submitted the information related to the DIA.
And by having your project reclassified from Category 3 to Category 1, you avoided having to file a detailed environmental impact assessment, or EIA, is that correct?
Yes, that is correct.
And EIAs were required for projects with significant environmental impact, correct?
Yes, as you know, there are two varieties of EIA, Category 2 and Category 3, with different levels of obligations associated with each.
And obtaining approvals of EIAs could take approximately a year, whereas DIAs took only about 30 business days to obtain, correct? Claimant said this at Memorial, paragraph 42.
That is what it was supposed to happen. Our DIA, as I said, was issued in September 2014, which was obviously 7 months after the reconsideration process was approved. So clearly it can take longer than 30 business days. It's supposed to take 30 business days.
In its Amparo ruling, the Arequipa Constitutional Court concluded that you should have filed an EIA rather than a DIA. Is that correct? Is that consistent with your understanding, at least?
I have attempted to read the Amparo, both Amparo rulings several times, and they're a little bit impenetrable. As best I can understand, the court ruled that the position or the reconsideration by the authorities was not buttressed with enough information to justify the switch from Category 3 to Category 1. And therefore, more information was required. I will confess that these were very difficult opinions to read, whether because of translation or because the background laws were opaque.
Did your Peruvian lawyers not advise you on what the Amparo ruling concluded?
The Amparo ruling occurred long after both Amparo rulings occurred long after the projects had been terminated and destroyed by the actions of Peru. They were of interest, but I have attempted to give you my best understanding of what they said. I would refer you to our Peruvian experts to get a far better understanding.
Yeah, no, it's just that you mentioned the Amparo proceeding in your own witness statement. So it seemed to me that these were fair questions, but I understand. You stated in your first witness statement at paragraph 3, quote, "I started financing renewable energy projects more than a decade ago because of my strong personal interest in energy sustainability and reducing the catastrophic effects of global warming." Do you remember that?
Yes.
And today you said, I quote, "I have a firm belief that the problems with global warming are going to be the most significant problems for the entire world for the next 50 or 100 years. I thought that was a good way to try to ameliorate that," close quote. Based on that, is it fair to conclude that one of your principal motivations for investing in Peru was to protect the environment?
Absolutely.
And given your answer to that, and since Peru is a big country, one option for you would have been simply to pick a place for your project that was less environmentally sensitive than the Mamacocha Lagoon. Isn't that true?
As I said,
gone somewhere else.
The nature of our project, the fact that it is a small scale run-of-the-river project in an area where, even the usual negative consequences of a run-of-the-river project, which is that it dries out the river in between where you take the water out and where you take the water back, would not apply because of the massive amounts of springs, meant that I was perfectly comfortable building this project with all of the protections we anticipated in accordance with the Equator or Equator Principles. So, I mean, theoretically, yes, we could have chosen a different project, but I believed and believe that choosing this project location and being environmentally conscious and appropriate are completely compatible.
The disagreements and controversy and legal proceedings in Peru over the type of environmental permits that you obtained and the reclassification from category 3 to category 1, et cetera, are a big part of the dispute that is the subject of this arbitration.
Yes.
In light of that, and given your stated concern for the environment, let me ask you this question then. At the time that the Peruvian authorities initially classified your project as a category 3 project, and therefore you needed an EIA, and you still had 5 years before the real COS, couldn't you have just erred on the side of caution? In other words, on the side of maximum protection of the environment by simply going ahead and preparing an EIA, and rather than fighting to have the project reclassified as a category 1 project?
If the reasoning of of ARMA at the time had not been so clearly wrong, that might have been something we considered, because we knew that ultimately, eventually, we would have to do all of the same things that were required by an EIS, and in fact, in 2017 and 2018, with respect to the environmental surveys and the like, we did all of that. But it was so clearly wrong-headed and so clearly out of step with what all every other similar project was how every other similar project was being treated in Peru, that we thought it was absolutely appropriate to ask for reconsideration.
Thank you, Mr. Jacobson. Mr. President, I have no further questions.
Thank you, Mr. De Rosa. I think we have now on the schedule 5 minutes for the package redirect. Is that correct, Mr. Molina?
I think we have, Mr. President, I think we have a reserved 60 minutes for redirect, if I'm not mistaken.
Oh, sorry, no, I got confused about the 5 minutes and 60 minutes. You need the 5 minutes for preparing for your 60 minutes redirect?
Yes, could we take a short recess and for 5-10 minutes, and we can resume redirect, please?
Okay. Mr. Jacobson, you're still in the testimony.
I understand. Thank you.
Feel free to move for personal reasons.
Yes, I'm getting old. I'm afraid that I do bio breaks more often than I used to.
5 minutes recess. '53, okay. Mr. Molina, please proceed with the redirect.
Thank you, Mr. President. Mr. Jacobson, I believe you're on mute as well. I think when we restart these sessions, we automatically start on mute.
Okay, can you hear me?
Yes. Thank you, Mr. Jacobson. Do you remember in your cross, Mr. De Rosa appeared to be critical of your lawyer's characterization of the Amparo decision as a nuisance suit? Do you remember when he was talking to you about that?
Yes.
Do you know what MINEM's view of this suit was during the process?
Yes, they believed it was illegal. That as the appropriate environmental agency, their determination of an environmental manner could be overturned only by another technical analysis, which the court simply did not do and was not in position to do.
If I could have my colleague put up on the screen C295. And if you, I'll wait for you to pull it up. Great. And if you could go to the, and I'm looking for the English version of this document, the English translation. Thank you. If you could just, if you control find completely illegal, I think it should get there.
Yeah, I'm gonna.
Okay. I believe it starts on page 7 of the PDF, again, in the English translation.
Mr. President, I hate to interrupt, but I did not ask Mr. Jacobson about MNEM's views, and if claimants are going to use this as a way to recycle their, their arguments and their pleadings, then we think that would be inappropriate. So
overall, it's because it relates to your characterization of nuisance, at least reference to it. Please proceed, Mr. Molina.
Thank you. I still do not believe that you have it up, Mr. Tom Byer. Right? Yep, that's the page. If you could look at the top where it's that paragraph and the sentence that starts with the aforementioned reports.
The aforementioned reports were issued by a competent environmental authority. Consequently, it is completely illegal for the lower court to annul a final generation concession granted on the basis of the environmental management instrument, environmental impact statement approved by the law, without there being any technical report issued by a competent environmental authority rebutting the favorable technical opinion contained in the technical report, and so forth.
Was MNEM a party to this proceeding?
Absolutely, as clearly.
And what were they? Is your understanding that they appealed the lower court's decision?
Yes.
Okay. And if we could go, okay, I'm sorry, continue.
Yes, because while it's a civil law state and so precedential authority is not, doesn't have the same effect, I'm sure, given that MNEM itself rules on the environmental situation of all large hydro projects, I'm sure this situation was very disturbing to them.
If you could now pull up Exhibit C305, which I believe Mr. DeRosa showed you, or at least mentioned during the cross-examination.
Yes.
Do you recognize what this document is?
I believe it is the English translation of the lower court Amparo decision.
Okay. And Mr. Byer, if you could go to page 13 of this English translation, please. To paragraph 1.2.5. I'm sorry, first, could you scroll up? I'm sorry, if you could just go to the page above first, just to put the context of what, do you see at the top of the page, there's a header called Allegations of Respondent, Ministry of Energy and Mines?
Yes.
Jacobson. And do you understand that this is a summary of the pleadings that the Ministry of Energy and Mines submitted in this proceeding?
Yes, I believe so.
Okay. If you go back to paragraph 1.2.5 and zoom in. So Jacobson, could you read this paragraph for us, or just the first sentence?
Claimant's claims are based only on his own allegations and are not supported by any specific technical report on the potential impact of the project, according to the evidence offered by claimant in his complaint, and has therefore failed to concretely and specifically assess the potential environmental impacts of the challenged project, which is backed by concrete and specific favorable technical documents under reports, the reports. For these reasons, respondent requests the complaint, I believe it should be dismissed.
And are you aware of any other parties to this proceeding other than MINEM?
I'm sure ARMA was a party, and I believe the regional government itself was a party.
And do you have any awareness of what their positions were vis-a-vis the allegations in the Amparo proceeding?
I believe they both opposed the Amparo proceeding on different grounds.
And when the court of first instance issued this ruling, do you have any awareness of what the other party's response was to that ruling?
They continued to oppose it, to plead against it on the appeal as being incorrect.
You just mentioned, thank you. You just mentioned ARMA. What's your understanding of ARMA's role vis-a-vis the Mamacocha project?
Well, ARMA was the regional authority which had been delegated the task of evaluating the environmental situation of the project and ultimately issuing permits that would then, as part of the concession process, be reviewed by MINEM and its own environmental experts.
Has ARMA always had the authority to review RER projects in its region?
No, it was given that authority as part of a process of decentralization, so that until I think it was 2012, those small hydro projects would have been reviewed centrally by MINEM, but after some particular point, that authority was moved to the different regions, and in the Arequipa region, that would be ARMA.
And you remember you were being asked earlier about ARMA's initial classification of the Mamacocha project as a Category 3 project. Do you remember that?
Yes.
And you mentioned that that it was your understanding at the time that the ARMA reached that rule or made that conclusion without a technical analysis. Is that a fair characterization of your testimony?
Yes, my understanding was that they had not that because of a misguided belief in what was required, they had not actually gone up to the site and done the requisite technical environmental reviews. And
just so we're clear, after the initial classification, what is your understanding of what ARMA officials did to complete the technical analysis of the Mamacocha project?
They went to the site and did an assessment. And
do you have any other understanding of anything else that was done by ARMA?
Well, it was sort of a two-part process. First, they had to decide if there were grounds for reconsideration, which did involve going through and doing the technical analysis of whether of what sort of category the project should be put in. And once they had made a determination as to what sort of category the project had to be put in, then there was a further process of analyzing, in this case, the additional information that we provided as part of the DIA process before issuing the permit.
Mr. Jacobson, you were asked earlier about your interest in the environment and in particular in ameliorating the effects of climate change. Do you remember that?
Yes.
Did you commission any environmental studies for the Mamacocha project?
Yes, we commissioned quite a number of studies, starting with the environmental part of the pre-feasibility and feasibility studies, and then some specific studies directed towards the otter population, which had been identified as a protected species that was nearby. And ultimately in 2017 and 2018, in order to meet the DEG's requirements under the Equator Principles, a quite fulsome analysis of the site, both in the dry and wet seasons.
Could you expand a little bit of your understanding of the Equator or Equator Principles?
The Equator Principles are a set of internationally agreed principles designed to ensure that development, particularly development sponsored by development banks, is appropriate and takes into account both social and environmental factors in the areas where the project is to be. It is quite extensive in terms of its requirements, both in terms of an initial assessment, as I said, in various different seasons where there are seasonal differences, and then in the monitoring that has to go on throughout the construction and operation of a project that is subject to those principles.
If you could, what range of, how much money do you believe you spent on in your attempts to comply with the Equator Principles while the project was still in existence?
Hundreds of thousands of dollars. I don't know the exact amount.
Was it required under Peruvian law to comply with those principles?
No.
So why did you comply with those principles?
Because we thought that, because we thought it was the appropriate thing to do, and certainly one of the things that happens when you choose to use a development bank as opposed to a commercial bank is that you are going to be required to do extra work on both the environmental and the social side, because development banks exist to develop the appropriate projects in their view in the countries where they are active.
But you could have gone to another bank that wasn't a development bank.
Yeah, I don't believe commercial banks have the same, at least some commercial banks do not require the same degree of work.
So you chose to be subjected to those principles?
Yes.
When you mentioned earlier the otter, what was your understanding of the allegations from the regional government about the otter, just so we understand the context?
I believe that they were alleging that the project would destroy the otters, would destroy their habitat, would kill the otters directly or indirectly, obviously nothing could be further from the truth.
Did you ignore those allegations?
No, we commissioned a series of studies by both local and international otter experts to study the habitat in the immediate region, and we had a couple of symposiums in Arequipa and in Lima, and ultimately we asked the researchers who had done the work to opine as to whether the project would harm the otters, and they concluded that with the mitigation factors that we were putting in place, there would be no harm to the otter population.
During your cross-examination, you mentioned the witness statement of Jorge Chavez. Is that correct?
Yes. Who's
Jorge Chavez?
Jorge Chavez was the principal of one of the EnviroSys, I believe, one of the environmental specialty companies that we had hired, and his role was to do the work required by DEG, the environmental work required by DEG under the Equator Principles.
If we could put up Mr. Chavez's witness statement, please.
President, again, I hate to interrupt, but we're getting quite a bit of field from the questions that I asked Mr. Jacobson, and the rules are that the redirect is supposed to be circumscribed to the questions that were asked on cross-examination.
We are not, wait a moment, Mr. Molina, you are not yet there, but you are really searching for the limits. Let's put it, you're approaching limits, so be careful.
Thank you, Mr. President. I am simply, he mentioned in an answer, Mr. Chavez, and I just want to make sure for the record that there's a full record of exactly what he was referring to. So if you could just pull up Mr. Chavez's witness statement, we'll be quick. You just go to paragraph 7. Mr. Jacobson, are you familiar with this document?
Yes.
Do you mind reading this, the second line of this, or just this entire paragraph?
I understand respondents alleging that in this arbitration, it was reasonable for ARMA to have classified the Mamacocha project as a Category 3 project based on my experience advising projects located in Peru and my real-time assessment of the Mamacocha project. I believe that respondents' contention is wrong.
Okay, thank you. Going back to the permit reclassification in July 2013, in October 2013.
Mr. Molina, what was the question actually? That the witness can read?
Thank you, Mr. President. No, the question was, is that your understanding that was that his conclusion, his overarching conclusion in his witness statement?
Okay, please answer the question, Mr. Jacobs.
Yes.
Okay, thank you. Back to the reclassification of the environmental for the environmental permits. Mr. DeRosa asked you if you had managed, and I'm quoting here, managed to get the authorities to reconsider. Did you put any pressure? Did you or your team put any pressure on ARMA to reconsider?
No, we obviously presented our reasoning as to why the initial reclassification was wrong, including, I believe, new evidence. And then it was entirely up to ARMA to make a determination as to whether that initial classification was correct, which they could have done, or whether the project should be reclassified into a different category.
Thank you. And lastly, on these issues, going back to the amparo, you mentioned the cross in one of your answers about the balancing of the equities. Could you just expand on what you were trying to explain?
Yes, in the amparo decision, there is a section where the judge has to look to the damage to the private party, which is us, and compare that to the potential damage to the environment, which was the purpose of the amparo. because the project was at that point, as the judge noted, in suspension and had not been constructed and was not being constructed, the court was able to quite quickly conclude that there was no countervailing reason not to knock out the environmental permits.
If you could put up C305 and go to section 3.7, please. It should be the second to last page. No, not that. I'm in C305. Is this C305? There you go. Keep going down. I think it's the second to last page. I think there's more than one section 3.7 because it repeats.
I think it's, sorry, Mr. Molina, I think it's 3.5.
It's a section that's titled Analysis of the Principle of Predicting Consequences. Maybe that's the easiest way to search for it. But again, I do believe it's the second to last page of this document. There it is. All right. Do you see, is this the section of the Amparo decision that you're referring to, Mr. Jacobson?
Yes.
Okay. And so just so I understand, it's your understanding that so let me ask you, if the project had been completed and had achieved commercial operation, what is your understanding of the likelihood that this decision would have come down as it did?
I think the court would have had much more to think about, given that there is a constitutional right that we have to not have the state violate our rights, and obviously in this case they looked at the Osinerman website to determine that the project was had not been completed and that there were no other consequences to consider. I think that if the project had been completed or even was about to be completed, the court would have had to do a balancing between the damages to the project and the area and the economy and all of the other things that ruling in favor of the plaintiff would cause that simply wasn't done in this case. And I certainly can't predict how the court would come out. I suspect that they would have come out differently.
All right, if we could go now to paragraph 17 of your first witness statement, please. I believe you were asked several questions about this paragraph during your cross-examination.
Yes.
Is that correct?
Yes.
Okay. In particular, you were asked about the second sentence in this paragraph. Is that right?
Yes.
Okay. Just to be clear, were you trying to flip the Mamacocha project to Interjex?
No. I mean, hydropower projects have one wonderful feature, which is they last forever. And this was a project that I was hoping that we could develop and have a interest in. And, that interest is something that could be passed on to my son and so forth and so on. Because, operating hydro projects are not only wonderful economically, but they indeed do last, I can't say forever, but I can say, for more than a century.
And again, in this paragraph, you're referring to other concessionaires from the first two RER auctions. Is that right?
Yes.
Okay. And was it your understanding when at the time that these concessionaires that you're referring to in this paragraph were had spent millions of dollars developing the projects that they were awarded?
My understanding was that the projects that were that sort of triggered the concern by Osinnerman were ones where the developers had not been spending money to develop the project and were in fact looking for others to take on the projects and develop them from scratch.
And how much money did you spend developing the Mamacocha project?
That depends on the dates that you ask, but I think it was somewhere around $20 million by the time the project ended in the end of 2018.
And was your understanding that these other concessionaires were maintaining an interest in the projects that they were trying to flip?
No, flipping the project means selling it.
And were you planning to maintain an interest in the project if you were able to complete your deals with Interjex?
Well, obviously in 2017, our expectation was that we would remain a partner going forward.
If you could go to R175, please. This is the Interjex, the email to Interjex that you were shown during your cross-examination. Is that right?
Yes.
And just to confirm, you mentioned something about the date. Could you just expand, just to be clear, what the date of this document is?
It's January 22nd, 2018. So about after the after the RGA lawsuit had been filed and while it was in the process of being dismissed.
Okay. If you could, thank you. If you could go to that in the bottom of that first page in the paragraph that starts there, I'll give you a second to, if you could zoom it up and you could just read. My question is, I'm sorry, if you could go to, it's the first paragraph. Yep. So you mentioned here the resolving the issues with the regional government of Arequipa. Could you just explain at the time in January 2018 what the status was of the project with its dealings with the regional government of Arequipa?
Yes, at the end of December, the regional government had announced that it would withdraw the lawsuit, although in fact the process of withdrawal was took a while, and I don't believe was completed until March.
Okay. If you go to page 2, and I believe it is. It's the second paragraph, the one that starts with, "We do not need to make one important change." If you could just take a moment to look at that.
Yes.
Okay. If you could read the sentence, just so we have it in the record, the one that starts with the combination, please.
The combination of the reduction in the valuation of development work that agreed upon in September and the cost of the roughly 1-year delay in the project, including the extraordinary costs related to dealing with the litigation surrounding the project, have turned that taxable gain into a substantial loss. Accordingly, it is important for us to structure the transaction in a way that would recognize this loss for tax purposes.
During your cross-examination, when you answered one of Mr. DeRosa's questions by saying that this was a distressed asset sale, is this what you were referring to?
It's part of what I was referring to. I mean, the reality was that notwithstanding that at this point the RGA had announced that it would withdraw its lawsuit, the valuation of the project had been badly affected And indeed, Interjex responded to my letter here with a lowball offer of $2 million. But it was also, I mean, this project had been running for a long time, and was both Mr. Benjir and I were sort of coming to the conclusion that we needed to get out while we could get out, and so we were eager sellers.
Okay. In your cross-examination, you were asked about the RER contract, and I believe you had it pulled up on the screen. Do you remember that?
Yes.
Okay. If you could pull it up, but in the meantime, can you just explain what was the point from your perspective of obtaining an RER contract?
Well, an RER contract as intended by the RER law, did a number of very positive things. First, it gave us a guaranteed revenue stream for 20 years. It gave us a preferential
You got it.
preferential connection to the grid, and it gave us the help of the ministry.
You were shown. If you were asked questions about financial closing, do you remember that?
Yes.
Are you familiar with the definition of financial closing in this contract?
Yes, I have seen it.
Okay, can we go to clause 1.4.9? Is this a definition that you're familiar with?
Yes.
And what's your understanding, or what's your interpretation of this definition?
Financial closing is the date when we've not only signed agreements with, I think the presumption is a bank, but the conditions precedents under that contract with respect to making disbursements have been met.
And you say the presumption's a bank. Why do you say that?
Because as Mr. Whalen, our expert, testifies, the whole of the RER law was designed to make these small hydro projects bankable, such that people could get non-recourse financing. That was certainly our intention. That was the intention, as far as I know, of all of the other bidders in the auction. And well understood that banks, have requirements before they give credit approval, and they have further requirements before they sign, and then they have further requirements before they actually disperse money, which is usually after the equity holders have fully paid out the amount that's been agreed.
And you were shown clause 6.4. Maybe we can go to that clause in this contract. Okay. Do you remember being shown this clause earlier today?
Yes.
Okay. In particular with 6.4.1, was your understanding that the ability to mortgage or pledge the future revenues, that's something that was available to you at the time of the signing?
Yes.
And why was that your impression?
Because it says that that's what the concessionaire company may do.
Did you think that you first had to achieve commercial operation to be able to close on a mortgage or a pledge of future securities?
Absolutely not.
And why not?
Because the contract is effectively a property right.
What do you mean by that?
I mean, the contract is something that under Peruvian law can be used as an asset to secure a mortgage, or as security for any of these other asset-based ways of securing financing.
Mr. Jacobson, you've testified and you said it today on cross that you used to work at eBay. Is that right?
That's correct.
And so you have experience with closing deals. Is that fair to say?
Yes, I've negotiated dozens and supervised probably hundreds.
And you have experience with banks and lending institutions?
Some, but I have to say the virtue of working for a profitable company is that you don't have to borrow money nearly as much.
Yeah. If the concessionaire had assumed all risks related to the project at the time of signing, would you have been able to mortgage the contract?
No, I doubt that any bank would accept the risk of counterparty misconduct.
And why wouldn't they accept that from your perspective?
Because the only asset they have is the definition of non-recourse financing is the only asset they have is the assets that have been pledged to them. And if those assets become valueless, then all of the money that they will have loaned is gone. There's nothing they can do.
Did you believe this contract had value when you received it?
Absolutely.
Did you invest in reliance of that belief?
Absolutely.
You let me see, give me 1 second. You were asked today about document, and I'm trying to R153, I believe is the document that you were shown. If you could go to that document. Do you remember being shown this document earlier today?
Yes.
Okay. Could you just describe what this document, this is an email from Lisi Benzaquén, who you said was your lawyer, correct?
Yes.
And in this summary, or this email is attaching a document, is that right?
Correct.
And you looked at it earlier today?
Yes.
What is this document that's being attached to this email?
I would characterize it as an English summary of the bid, bid requirements, maybe I'd call it.
These are the bid requirements for the third public auction?
Yes.
Okay. Was your understanding that this was a legal opinion?
No, I think it was an English language summary of what was in those bid requirements.
If you could go into the attachment, please, and in particular, if you go to the section where I think it's the next page. One more. No, sorry, keep going. I do believe it's that one. Yes. So you see here on section 3, remember you were asked questions about this section?
Yes.
Okay. You mentioned when you were being asked a question about subsection B of this paragraph, that you did not believe that the commercial operation deadline was immovable. Can you just expand as to what the basis for that belief was?
Yeah, well, as I said, we applied for an amendment to the contract in, I believe it was 2016, which was duly approved by MINEM and ultimately signed by I believe it was the Vice Minister of Electricity, which had the effect of changing our commercial operation date from and the real date of commercial operation to March 14th, 2020.
When you signed, when your company signed the RER contract in February 18, 2014, did you believe at that time that the commercial operation date was movable?
We believed it would be movable if the reason for the moving had to do with the actions of Peru, which was our counterparty.
And what was the basis for that belief?
There were a number. There were particular points in the contract, including the fact that it was subject to applicable laws, including the Civil Code and the Constitution. There was the fact that the purpose of the RER law was to encourage the development of RER projects, including mini hydro projects. The requirements under the civil law that so there were requirements under the civil law that parties could not take advantage of their own bad deeds in order to get benefits, and under the administrative law that regulations and contracts under a particular set of administrative laws had to comport with the purpose of those laws. So we very much believed that should it become necessary, we would be able to move the COS, and for that matter, the term date of the contract, if the reason for that movement had to do with actions by the state.
You mentioned a few minutes ago that you've reviewed hundreds of contracts. Is that fair to say?
Yes.
Have you ever seen a contract that allocates all risks to one of the counterparties?
I've never seen a contract that would allow one party to breach and not give the other party recourse.
And why do you think you have not seen that?
Because no one would enter into any such contract.
And why wouldn't anyone enter into that contract?
Because it's not a real contract. It's effectively an option. The other party would have the ability to, if it liked the contract, to hold you to its terms, and if it suddenly didn't like the contract, to cause it to fail.
Had you known at the time that this was Peru's interpretation of the contract, would you have signed the contract?
I wouldn't have entered into the option.
You were shown another document related to the third auction. I believe it was R138. If you could pull that up. This is, you remember being asked about this document?
Yes. Okay. Yes.
And you remember that it was a sworn declaration about the immovable nature of the termination date, even in events of force majeure. Do you remember that?
Yes.
Were you ever shown, or was the risk that you were assuming all risk related to the contract? Was that ever expressly disclosed to you or to your team during the third auction?
No, all of the references all specific references were to force majeure, which I understood to be causes that were unrelated or not under the control of either party.
Would a delay by a permitting authority, from your perspective, be a force majeure event?
No, because that was under the control of Peru.
And would an action by the regional government of Arequipa against the project be a force majeure delay from your perspective?
No, for the same reason.
What about the actions of MINEM?
No, for the same reason.
Give me 1 second. You were being also shown some documents from DEG. Could we go to R177? Do you remember being asked about questions about this document?
Yes.
Okay. And this was a sort of a question and answer document between your companies and DEG. Is that right?
Yes.
Okay. And do you remember that there was a comment here about the Amparo?
Yes, I believe question 7.
Yeah, if we could go, just pull that on the screen. This is the one?
Yes.
Okay. Do you see, well, let me ask you, you said earlier you were involved in the negotiations with DEG, true?
Yes, although Mr. Sillen was much more directly involved.
Were you aware of any, was it your understanding that the DEG was unwilling to move forward with this project because of the Amparo decision?
Absolutely not. They were eager to move forward.
And I said Amparo decision, I meant the Amparo proceeding.
That's correct. The Amparo proceeding, which was ongoing at that point, and as I noted, even a year later, was still considered or more than a year later, was still considered a remote contingency.
Do you see that in the red font under subparagraph B? Have you had a chance to read that response to one of the questions?
Yes.
Is there your understanding that your company prepared a legal report for DEG's review about the Amparo?
I believe our lawyers prepared a report for review by DEG's lawyers.
So you told DEG about the Amparo?
Yes.
Did you tell Intergex?
Yes.
And was Intergex concerned about closing on the agreements with Mamacocha because of the Amparo?
No.
If we could go to the C247, which is I think the other diligence document regarding the Amparo. Okay, if you could go to, you remember being asked questions about this document, Mr. Jacobson?
Yes.
Okay, if you could go to page 3 of this document under Romanet 2. I'll give you a chance to read this document. Read this part of the document. Okay. What's your understanding of what CMS Grau is communicating through this document?
I think this is a more detailed explanation of why they viewed the probability that this would actually become a problem as remote, in their words. Okay. And so they give the 3 reasons why in their opinion, the proceeding should ultimately be dismissed.
From your understanding, why is CMS Grau even looking at the Amparo proceeding in December 2018?
Because, as I said, this was updated due diligence because of our expectation that through the mechanism of the Supreme Decree, we would be in position to continue working on the project.
Could you explain what Supreme Decree you're referring to?
I'm sorry, the Supreme Decree that was issued in November of 2018 that would have the effect of giving projects like ours, which have been slowed down by governmental measures, the full 20-year term and a full restitution of the COS date. When it was enacted.
Mr. Chairman, sorry to interrupt, but I didn't ask him, Mr. Jacobson, about the draft Supreme Decree, which is I think what they're what they're talking about. And I was very patient with the discussion of the otters and whatever else was being thrown at Mr. Jacobson. But I think that they have exceeded the the limits of the redirect.
Sustained. Please move to the next subject.
Mr. Jacobson, you were asked about not challenging the what you were told, or you were asked about the fact that you had your companies are not challenging the Amparo decisions under this arbitration. Do you remember that?
Yes.
Why are your companies not challenging the Amparo decision?
Because those decisions all occurred long after our project had been destroyed.
I just take 1 second. I don't have any further questions. Thank you.
Thank you, Mr. Molina. I look to my colleagues. First, Mr. Tawil, you have questions?
Thanks, Mr. Chairman. Yes, I have a question. Good morning or good afternoon, Mr. Jacobson.
Good morning, Professor Tawil.
I'm interested in knowing a little bit more what happened in December 2018. I mean, why was sort of what claimant alleges as a change of position by the government? Could you give us your recollection about what happened in 2018, in December in particular?
Well, as you know, there was a proposed Supreme Decree. The government received commentary from 2 natural gas producers and Osinergmin. The negative commentary from those, and ultimately decided to do 3 things. Not move forward with the Supreme Decree, not give us the extensions we were expecting related to the suspension period, and the others asked for in our 3rd extension request, and to file the Lima arbitration.
And do you attribute the change of position to any particular cause? I mean, the influence of the gas producers. I mean, I would like to know what was your feeling. What was your understanding of why the government changed the position?
Well, we were certainly very surprised because it was a very abrupt change without there having been any change in government. The best we could figure out was that it was the influence of the natural gas lobby and the concerns, the financial concerns that Osinergmin had expressed that suddenly resulted in this remarkable change.
I assume I'm not an expert on the Peruvian electricity system, but I assume that the hydroelectric plant that you were constructing was a small one, and that would not have affected the price of the energy. Am I correct on that?
Yes. Well, it would have had at best a negligible effect because it's a tiny drop in a large ocean.
Okay. Thanks. I have no further questions, Alberian.
Thank you. Professor Venuesa, any questions?
No, I don't have any questions. Thank you very much.
Okay, I have a question. Could again be shown a document R138? Mr. Molina, can your technician show it? Oh, yeah, great. 138. Yeah. All right. So, Mr. Jacobson, you have been asked already questions before this, before about this document, both in cross and redirect. This is the statement by Mr. Canseco. Is that correct?
Yes.
And he was the general manager of CHM in Peru.
Yes.
And he declares under oath that he recognized on behalf of the company, and the company is
HLA at the time.
Yeah. That the date of the termination date is not movable. You see that?
Yes, for any reason, including force majeure.
Yeah. All right. So, do you recall what the termination date was under the contract?
December 31, 2036, I believe.
Correct. Yes. Now, if you then go to the amendments of the contract, Amendment 1 and 2 concern the commencement of the commercial operations date. Is that correct?
Yes, both of those move the COS date.
Yes, COS date. Ultimately, they moved to 2020. So I think 31 December 2020. Is that correct? Or 31 March 2020?
Yes.
Yeah.
14 March 2020.
Pretty much aware. Okay,
Yeah.
I'll give you the 2 weeks. That left then for the revenue stream 17 years. Is that correct?
As of what date? I'm sorry.
So if you have the termination date of 2036 and you have the commercial operations date, start date in March 2020, you have some 16 to 17 years left.
Yes, I think just under 17 years. However, our understanding of the suspension.
I come to that. Sorry. Oh, no, I don't want to cut you off. Please finish your answer.
Well, but our understanding of the suspension was a suspension. A suspension operates to sort of like injury time in soccer. It stops the clock and then puts the time back on the clock at the end, and that was our expectation as to what would happen with respect to not just the COS but also the PPA.
Okay, so the works execution schedule.
Yes.
Suspended specifically, wasn't it? And let's separate these two. So the dates in the works execution schedule were suspended, which included the financial closing date. Is that correct? Under the amendments 3 to 6.
Yes. At least as I understood it, the clock had been stopped, and we would be put back into the same position we had been in when the clock was stopped.
So when then, as my colleague Professor Tawil referred to, when the Supreme Decree was being discussed in 2018, that Supreme Decree was intended, if I understand correctly, for moving the termination date on the various contracts. Is that correct?
I think it did both. I think it gave the possibility of moving the COS date, and where the reason for the delays was due to the government, it also gave the opportunity, upon submission of appropriate documentation, to move the termination date.
So if that date were not moved, then you had an issue in getting financing for your project, isn't it? That date, I mean, sorry, the termination date.
Yes, if the date was not moved either because of a Supreme Decree or because of an agreement with MINIM or because of the suspension. If nothing moved that date, then we would have had an issue we would have had fewer years for our loan and would have had to put up more equity, and I don't know what the outcome would have been.
Mr. Jacobson, what you see now is still on the screen, that Exhibit R138, about the Declaration on the Oath, that tracks another decree of 2013, isn't it? Which again,
yes, but in both cases, the focus was on force majeure. It seems to me that if the Peru wanted to make it clear that also included was actions by the state, they would have said something.
And would you distinguish between actions by the state and actions by some local authorities?
Well, as I understand it, the state is the state, and that includes the local authorities, to whom obviously a lot of governmental functions are delegated.
Yeah, but if the contract provides a provision that says that the state would assist you in permitting, isn't it?
Yes.
Would that not indicate that there are two maybe internal divisions, in that the one is assisting, the other one is doing the permitting?
Yes, and I understand there is a dispute about what assist means. Presumably it means more than best efforts, because the other portion of that clause, which has to do with third parties, says best efforts. But there is I sort of come back, and again, I'm not a Peruvian lawyer, but my understanding is that it is a unitary as opposed to a federal state, and that when the state speaks as the state, it is speaking not only on behalf of the central authorities, but also of the regional authorities.
You enter into a discussion about attribution.
Yeah, and I suspect there will be much discussion about that between the Peruvian legal experts upcoming.
So have you, in your professional life, advised or been engaged in tendering? Tendering on projects, trending?
It's not been a significant part of what I do professionally.
Have you ever been involved in a tender before this tender on the third auction?
No, I don't believe so.
My question would have been, but then I could maybe you wish to answer, maybe not, is that in this tender process, usually tenderers try to minimize their exposure by making qualifications, and if that's not allowed to make qualifications, what you do is via what you seek clarifications of the tender documents. Have you thought about that at the time you made the tender, or your company?
We didn't ask for a clarification that the state couldn't breach the contract with impunity, and neither did any of the other 25 bidders. And I assume it's because none of us thought that was even within the realm of the possible.
Yeah, but when you have a termination date which is declared as one of the tender documents to be immovable, would you not seek a clarification? Wait a moment, but there may be circumstances that the thing should be movable outside force majeure. Did that not occur to you?
Well, as I said, our reasoning at the time, which and I can't speak for the other 25 or other 24 bidders, but our reasoning at the time was that Peru had very clearly highlighted the fact that the tender could not be moved for force majeure reasons, which is unusual but not unheard of. And obviously, it would not be moved for actions of the bidder. But we just didn't believe that without any notice that meant it wouldn't be moved because of actions of the state.
But for other reasons, so could it be moved for other reasons on the basis of a contract amendment? In your view of the contract at the point in time, because what you have is you have a decree, and you have a statement which says the termination date is immovable for any reason, and your understanding is yes, that may all be true, but except for cases that are attributable to the counterpart, in this case the state.
Correct.
That the way I understand your testimony?
Yes, that's correct.
Right. And one small point, paragraph 76 of your first witness statement. Maybe it can be shown on the screen. 76.
Yes, I've got it.
Sure, you got it. So you state there that in December 2018, okay, it will be shown on the screen. 76. Okay, it's the first sentence. See it on the screen. Says in late December 2018, I learned that Minam unexpectedly decided to abandon its proposed supreme decree based on the public comments of Osinergimin that encouraged Minam to let the project fail so that it could benefit from approximately $55 million in performance bonds deposited under the relevant contracts. To your knowledge, have the bonds indeed been called for $55 million by Peru?
Well, I know that some of them have been, because that was the subject of some of the Lima arbitrations that have already occurred. In several of those arbitrations, the tribunals determined that the bonds could not be called, and those obviously were not. So I'm quite certain that Minam has called those bonds that have been through an arbitral process, and where the arbitrator said that it could. And I don't know for sure, but I see no reason why they wouldn't have been calling other bonds if there was no dispute.
Thank you. Do you know how many cases that happened, by any chance?
I believe it was at least 2 of the 4 that were cited by Peru. I mean, obviously some of the projects have been completed, so there would be no cause for calling those bonds. I do not know how many of the others have been called.
The bond you issued as far as $5 million, wasn't it?
That's correct. That was a tiny $71,000 bond for the transmission line as well.
And still outstanding, that bond?
Oh yes, I pay fees to the banks every 6 months.
100,000 you said per year, is that?
100,000 per year, yes.
Right. Could you talk about money? Can we show paragraph 42? It's the last question Mr. Jacobson I have. So simply to get for figures, how much finally was spent by you and your co-venture, Mr. Benji?
Benjir.
Benjir, sorry, actually. You testified earlier today it was 20 million, is that correct?
No, I believe I testified that the total amount that had been spent through December 2018 was approximately 20 million, yes.
So if I would characterize it as sunk cost, is that 20 million?
At that point,
At that
yes.
point.
Yes.
And how much did you spend thereafter?
Well, after that point, most of the expenses have been those involved with the Lima arbitration and this litigation. I think the Lima arbitration was $800,000 or $900,000 total, and unfortunately, this litigation has been much more expensive.
Thank you. Thank you, Mr. Jacobson. And now I turn to counsel, Mr. Molina. Do you have any follow-up questions? Following the tribunal's questions?
Yes, I do. Thank you, Mr. President. Quickly, if you were asked a question about from the president about clause 4.3 of the contract about the assist obligation,
Yes.
I think it'd be great if we could put it on the screen, just so you have a chance to just look at it again, because I believe it's an important question. And while it's getting pulled up on the screen, I believe the question was essentially if the state was assuming this obligation with respect to the permitting authorities, work in assisting in you obtaining permits with respect to those that have been delayed. Could you just take a look and just refamiliarize yourself with this clause? Let me know when you're ready.
I'm ready.
Okay. Whose obligation is it to assist you in the permitting?
The ministry.
Okay. And who's the ministry?
I believe that's Minim.
So it's not. Okay. Well, let me just move on to another question. You were also asked about clause, or if you go back to R138. You were being asked about the force majeure and the immovable nature of the termination date.
Yes.
Yes. Let's assume that the termination date could not be moved, and there was interference from your counterparty. Do you believe that this document or anything else in the contract absolves Peru from having to pay you damages?
No, I mean, clearly that's the other alternative. If a counterparty breaches and it cannot be resolved by additional time, then presumably it has to be resolved by money damages.
Okay. And lastly, there's been a lot of discussion, and Mr. President also raised it about what's written on a contract or what's written on some of these documents. Is there, from your perspective, are there ever terms that are implied and not written expressly into a contract?
Of course, contracts always are buried in the context of the relevant laws and people's understandings of the context in which they're written.
And could you give me one example of a principle that would not be expressly written but would be implied?
Good faith.
Okay, thank you. No more questions.
Thank you. Mr. De Rosa?
Yes, thank you, Mr. Chairman. I just have one question for Mr. Jacobson. The chairman asked you during the process for the basis for the consolidated basis, the bidding rules, there was a comment period, right? Did CHM submit any questions or comments to the authority?
My understanding is we did.
And none of those had to do with the scope of the termination clause?
Yes, that's correct.
Thank you. No more questions, Mr. Chairman.
Thank you. I look to my colleagues. Any follow? No, nothing. All right, Mr. Jacobson, thank you for testifying. You know, excuse as a witness.
Thank you very much.
Recess for 45 minutes until 1940 CET. Mr. Molina, you have a remote to turn around, to look around?
Yes, it's we're in the modern age here at in these offices, and if you could tell, I was still struggling with it, so I'm still getting accustomed to the modern age.
I like very much Mr. Riesenfeld looking above when speaking to the tribunal.
Yeah.
All right,
Thank
okay.
you, Professor Twill.
Mr. Riesenfeld or Mr. Molina, you call your next witness?
Yes, Mr. Molina will be taking care of our next witness. Thank you.
Okay, Mr. Molina.
Yes, Mr. President, members of the tribunal, this is Stefan
Hello.
Dillon.
I'm sorry. Excuse me. Can you hear me?
I can hear you. Can you hear me?
I'm getting this. Oh, okay. Thank you. Can we start over, please?
All right, I invite Mr. Molina to call the next witness.
Thank you, Mr. President, members of the tribunal. Our next witness is Mr. Stefan Sillen.
All right. Good afternoon, Mr. Sillen. You appear as a witness for the claimants. Could you please state your full name for the record?
My name is Goran Stefan Sillen.
Mr. Sillen, if any question is unclear to you, either because of language or for any other reason, please do seek clarification. Because if you don't do so, the tribunal assumes that you have understood the question and that you answer a response to the question.
Understood. Thank you.
Now, Mr. Sillen, you will appreciate that testifying, be it before court or out of tribunal, is a very serious matter. That the connection the tribunal expects you to give the declaration, the text of which will now be shown on the screen.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Sillen. Now, could you, there are a couple of additional confirmations I would like to have from you, because we are in a virtual hearing setting, not an in-person hearing. So could you please confirm that you're alone in the room?
I'm alone in the room.
And could you please confirm that you have not attended, watched, or recording or read the transcripts of the prior examination?
I have not.
Can I please ask you to scan the room to show whether there's anybody else in the room?
Yes.
Thank you, Mr. Sillen. Have you switched off your iPhone or any other device which you can communicate?
I have.
Thank you. If anybody, at any time someone enters the room, please alert the tribunal of this fact and refrain from testifying further until that person has left the room.
Will do.
Okay. Then finally, can you confirm for the record from which location you are testifying?
I'm testifying from Baker Hostetler's office in Washington, D.C. I'm in a separate room, and I have been isolated from the team throughout all yesterday, since Sunday evening.
Thank you. Is it, what do you have on your desk? You have your hard copy of your witness statements?
Yes.
You have access to the electronic records of the case?
No, as far as I understand, this room doesn't have access to the electronic records.
Could you please take your first witness statement of 14 September 2020? And go to page 56.
Yes.
Confirm for the record that the signature appearing above your name is your signature?
That is my signature.
Could you please go to your second witness statement of July 2021. Page 44.
Yes.
Could you confirm, please, for the record, that the signature appearing above your name is your signature?
It is my signature.
Thank you. Is there any correction, amendment, or modification you would like to make to either witness statement?
I have a small correction to my first witness statement. It's in paragraph 162 on page 52. In the first sentence, the year should be 2018 rather than 2020.
So it's on December 20, 2018, would you say?
That's correct.
Great, yeah. Thank you. Anything further?
No, apart from that, I stand by my witness statements.
Thank you. Mr. Molina, please proceed with the direct.
Thank you, Mr. President. Good afternoon, Mr. Sillen.
Good afternoon.
Can you briefly tell us about your professional background?
So I have a master in business administration, strategy, finance. I have worked my whole career, with corporate development, due diligence, and mergers and acquisitions. I started working with energy for Vattenfall in mid-2000, and increasingly have, focused on renewable energy. I also worked for KPMG in the same position with due diligence, and since 2014, I led Latam Hydro and the team in Peru.
And can you briefly tell us about the team that you put together for this project?
So I wanted to have an expert team, a mix of both local, global experts. I hired Mr. Batrina as the project manager. Mr. Batrina has a background from Iberdrola Renewables and was responsible for project development in Eastern Europe. He also spent many years working in Latin America. I supplemented a team. We supplemented a team, as the project progressed with relevant expertise, whether it was social, technical, environmental. We worked with the best, in our opinion, experts, both on technical issues and legal issues. We had Santapañez, we had Poiri, we had Norconsult. We had several environmental and social experts around the team.
You testified that you oversaw the development of the financial strategy. Can you please provide a brief synopsis of what that strategy was?
So the RAB promotion and the contract was specifically designed for attracting foreign investment. It provided, a 20-year guaranteed revenue stream, and it had other protections as well. It was well suited for project finance, and that was the strategy that we pursued. We also sought a complementary equity partner to us, that could complement us, so that the team could use its abilities to develop a portfolio in Peru. We settled for DG, who shares the same vision with respect to social and environmental impacts. We chose Innergex because they had, long track record in developing, constructing, and operating hydro assets. So it was a good team.
Why did you start permitting more than a year before you obtained the RER contract?
We wanted to be diligent. We knew that time was of the essence. We wanted to be well progressed for when we participated in the third tender. We want to make sure that we had the most important permits, including the concession, and to be able to close the project as quickly as possible after that, preferably in 2014.
And could you please explain what happened with the environmental permits early in the project?
Yes, so ARMA wrongfully classified a product as a Category 3. A Category 3 is, designated for products with a very substantial environmental impact. You're building a dam, you're displacing people, you're, cutting down forest and the likes. Our products didn't have any of those characteristics, so we knew it was wrong. We understood from MINEM that it was authorized to approve products up to 20 megawatts. Our product was 20 megawatts. They took it as a sign, that they should essentially give us the highest category without having done any proper technical environmental assessment. So when we received that classification, we filed a petition for reclassification. That was in November, and November 2013. And ARMA made a reassessment. They actually did a technical assessment of the product. They went to the site. They saw that they had made a mistake, so they simply corrected it and classified it as a Category 1.
What was your understanding of the restrictions on extensions that were imposed shortly before the third auction?
We understood that the Ministry of Energy and Mines, they wanted to avoid. They had some bad experience from previous tenders where concessionaires had raised, flag of force majeure, even if there were delays caused by the concessionaire's negligence, and they wanted to correct that. They wanted to make sure, that if the delays were solely attributed to the concessionaire or acts of God, that would be that wouldn't be a reason to extend. We never interpreted as that also including interference or negligence or permitting delays from the counterparty of the contract. That wasn't anything we reasonably envisaged at the time.
And how did the extensions under Addendum 1 and 2, what was your understanding of those extensions?
That it reaffirmed what we understood, that if the delays, in this case, were essentially the fault or caused by the government of, the authorities, then that we could modify the works execution schedule.
And how did the extensions under Addendum 2 impact the financial negotiations?
Well, the negotiations had stalled for about 6 months, waiting for the extension. So when we received the extension under Addendum number 2, that energized it, and we moved forward in quick pace. We agreed in principle and terms with Energex in February. We worked together with Energex DG to make sure that we could close on the financing by May 2017 and to start construction in June, July, that time frame.
And how did the RGA lawsuit impact those negotiations?
Well, it completely derailed them. Both Energex and DG said that they couldn't close on the financing because the RGA lawsuit essentially threatened the environmental permit, and the environmental permit is, a foundational permit for the concession. So by extension, it also threatened the concession. So it didn't move forward. Simple as that.
There were other challenges to the environmental permits at the time of the RGA lawsuit. Is that right?
Yes, there were. We had some dealings, with with AAA authorities that didn't want to approve or deny to approve our permits for the civil works. We had following 10 or 15 days after the RGA lawsuit, we had a criminal investigation being opened. We didn't know much about it at the time, but so yes, there were several things happening at the same time.
And what was your impression of the contract suspension?
That it would stop the clock on the project. We certainly couldn't move to financial closing. It was very clear, to all of the parties involved, the Ministry of Energy and Mines, the Special Commission, that without, essentially suspending our obligations and, including stopping the clock, that it was simply impossible for us to do that. So that was created, for all the parties to be able to negotiate in good faith and see if we could find a solution.
And what's your reaction to Peru's position in this arbitration that the suspensions were never intended to result in extensions to the work schedule?
Well, that's odd, to say the least. I would say it's incredulous, because we, as a company, would never have entered into any negotiations unless that was being quite clear between parties. Why would we spend several months, even years, negotiating with a counterparty if we wouldn't be able to build a project on time? It wasn't. That wasn't the intention.
And what was your expectation when you and your team filed the third extension request in February of 2018?
That the Ministry of Energy and Mines, like they had done in Addenda 1 and number 2, that they would, sign a resolution where they would extend both the COD date and the term date of the contract. That was the expectation.
And why did you have an expectation at that time that the termination date could be extended by MINEM?
Because we had already raised the issue with both the Special Commission and the Ministry of Energy and Mines. We understood, that the Ministry of Energy and Mines agreed in principle that they were allowed to do it and that there were a legal mechanism to do it. So.
And what was your understanding of why they didn't do it? Later when they denied the third extension request?
Well, I'm still struggling to understand, but I'm understanding a little bit, that they essentially walk back on everything that they have done, including the extensions under Addenda 1 and 2, and the suspensions. And yeah.
No further questions. Thank you.
Thank you, Mr. Molina. Ms. Taveras, you doing the cross?
Yes, Mr. President, thank you.
Please proceed.
Mr. President, before I proceed with the questions, I have a question on procedure for you. Today, we're supposed to run 60 minutes with the cross and then the next 60 minutes tomorrow. I have organized my outline with that distribution in mind. I just want to make sure that we will be following the 60 minutes.
Yeah, because the blank in the schedule is a cushion, I understand, for the time if you would over. So please proceed with your 60 minutes, more or less. And your hands seek a natural moment where you think, well, to break, and then you can continue tomorrow.
Fantastic. Thank you.
Yeah.
Mr. President, if we could intervene, we were under understanding that the schedule was to be used in full each day, and that a party would not be able to have a witness held over unless it was absolutely required. And also, with respect to this schedule, the one which is in the Excel spreadsheet, that was strictly meant to be a suggestion. It was not meant to be binding on either of the parties. That was not our understanding that a witness would not be able to complete their testimony on a day should there be enough time in that day to do so. So we would suggest that Ms. Chavez complete her cross-examination and not hold over this witness.
Yeah, but see, the cross-examination is slated for 120 minutes, isn't it?
Yes.
So, if you are suggesting that we need to go for 2 hours now, it's getting late for me in any case. So late for some others. So I think 60 minutes, if you do 60 minutes more or less, because I give Ms. Taveras, of course, latitude to choose a natural moment in the cross as she wants to finish. And tomorrow we have to, again, we didn't then go on this next 60 minutes. The question, my understanding was, of the question for today, is that if we have delays of today so that we can make it up. But that's, we have a short delay. I think we are 10 minutes behind schedule, 15 minutes. So we comfortably end around 9. I'm all the time of CET time zones, time notation, I'm sorry. And 9:30 would be then, if you do slightly longer, well, it's fine. But that's in the hands of Mr. Taveras, because we are done right on schedule for tomorrow. This is not that we are downtime for half a day or so. That was the concern of the tribunal.
Thank you, Mr. President.
Yeah. Okay. Mr. Taveras, please proceed.
Thank you, Mr. President. Good afternoon, Mr. Sillen. My name is Claudia Taveras. I'm part of the team that represents Peru in this case. Today, I will be asking you a series of questions regarding the matters you addressed in your 2 witness statements. As you may know, your testimony is being transcribed and is also being translated into Spanish simultaneously. For the sake of the court, pardon, were you able to hear me properly?
I could hear you. I could hear you, but it was a little bit mumbled. So this is not. Thanks.
Thank you. I apologize for that. For the sake of the court reporters and interpreters, I ask that you wait until I have finished asking a question before providing your answer. For planning purposes, before I turn to my questions, I would like you to confirm if you speak Spanish.
I do not speak Spanish.
I see. Thank you for clarifying. Let's begin with your professional history. You have covered this topic in your witness statement, correct?
That's correct.
And you've also provided a copy of your CV.
That's correct.
Great. Let me make sure I have this right. You hold a bachelor's degree and a master's degree, right?
Yes.
Both degrees are from the University of Lund.
Lund, that's correct.
Where is the University of Lund?
It's in Sweden.
Your first degree was your bachelor's degree, right?
That's correct.
And it was in literature, media, and sociology.
That's correct.
And your second degree, which was your master's degree, was a degree in business administration, correct?
Correct.
Do you have any formal training in law?
No.
You are not an attorney, correct?
No.
After you earned your master's degree, you went out into the workforce, correct?
Correct.
And between 1996 and 2005, you held several roles in BSI and Partners and the Tetra Pak Group in Sweden, correct?
Correct.
And your work involved clients in the finance and technology sectors, right?
When it comes to BSI and Partners, correct.
And in Tetra Pak Group, what were you doing? What sector did that involve?
That was a project management assignment where the Tetra Pak Group was looking at new technical services. So we were essentially establishing a whole new business for Tetra Pak.
In November 2005, you joined Vattenfall Power Consultants in Sweden, correct?
Correct.
And it was thereafter that your career pivoted towards the renewable energy sector, correct?
That's correct.
At first, you focused on the Nordic markets, correct?
Yes.
and then you turned to the European markets.
Yes.
In September 2010, you joined Gray Invest Management, right?
That's correct. I joined Gray Invest Management.
And at that time, Gray Invest Management was a company owned by Michael Jacobson, correct?
Yes.
And until the creation of Latam Hydro in 2014, it was through the Gray Invest Group companies that Mr. Jacobson developed and financed the Mamacocha project, correct?
Yes, so there were a little bit different entities, but within the same, I would say, group. Once we had decided to move the development to Peru, it was conducted through a separate company, not to be mixed, with the European companies. That's correct.
But part of the same Gray Invest Group of companies owned by Mr. Jacobson.
It was owned by Mr. Jacobson, but it was still separate entities.
In paragraph 10 of your witness statement, you stated, and you have it in front of you, you said, right?
Yes. Is that the first one or the second one?
First witness statement.
Which page do you want me to?
Paragraph 10, and I will tell you the page right now.
Okay.
It's on page 3.
I have it in front of me.
Therein you state that in or around November 2011, your team at Gray Invest began scouting for possible locations in certain Latin American countries, and then those countries include Peru. And the purpose of that search was to invest, develop, and operate hydroelectric projects. Is that correct?
Yes.
Okay. Pardon, I will mute myself for 1 second. I'm hearing an echo. Apologies for that. So we were saying, we were discussing paragraph 10 of your first witness statement, wherein you stated that in or around November 2011, your team at Gray Invest began scouting for possible locations in certain Latin American countries, including Peru, to invest, develop, and operate hydroelectric projects. That's what you state in your first witness statement, correct?
That is correct, yes.
And in that same paragraph, after describing the members of your team, you say that together you had more than 150 years of experience developing energy projects, including decades of experience with hydroelectric projects in Peru and around the world, correct?
That is correct, yes.
But at the time, you specifically had only 6 years of experience with renewables.
That's correct, but I also had a team.
And you specifically had no experience with hydroelectric projects in Peru, correct?
That is correct.
You were Chief Financial Officer and Chief Executive Officer of Gray Invest Management from 2010 to 2012, correct?
Yes.
You also served as President and Chief Executive Officer of Latam Hydro until 2019.
February 2019, correct.
In paragraph 2 of your first witness statement, you state that as of February 2019, you have a consultancy role within Latam Hydro that remains in place until today. Are you currently a paid consultant for Latam Hydro?
I have been paid for helping to prepare my witness statements. Apart from that, I don't do anything for Latam Hydro.
Okay. So I just want to understand, what is exactly the scope of the consultancy role?
It is to assist with preparing my witness statements and other documents as a preparation for these hearings.
When you say other documents, what do you mean? The briefs, for example?
I have read the briefs, yes.
And other witnesses' written statements?
A few of them, yes.
Okay. So you've advised on the overall strategy of the case, you would say?
I wouldn't say that, no.
Are you being paid to testify here today?
I'm being paid for, the lost opportunity cost.
From 2011 through 2018, you were responsible for overseeing the development of the Mamacocha project, correct?
Correct.
Were you living in Peru at the time?
For the first 2 years, I was spending probably 3 to 4 weeks in Peru. And at that time, I was living in London, and that was my residence. So I went back to London for a week, 10 days, and then I went back to Peru. So I spent a lot of time in Peru.
You said for the first 2 years. And after that, what happened?
After that, we had established a team. We had, good progress on it. I still continued to travel very frequently. At that time, I had relocated to Miami, so it was a lot more convenient for me to travel back and forth. And I spent considerable time, but less time in one stretch, so to speak.
Your first witness statement, you had explained that you were the person who oversaw fundraising efforts for the Mamacocha project, correct?
That's correct. Correct.
You were the person that developed and oversaw the financing strategy for the Mamacocha project.
Yes.
In the end, did the Mamacocha project secure financing?
Well, it would have, but it didn't.
I would like to pull exhibit C144 on the screen. This is the CV that you appended to your first witness statement, right?
That looks right.
And I assume you reviewed it before you submitted it to the tribunal.
Yes.
But the document on the screen, that must have been an old CV, right? For example, it still listed you as the president and CEO of Latam Hydro, correct?
Yeah, that could have been my mistake.
In the description of your work experience at Latam Hydro, your CV states that you were, quote, in charge of a team of 10 professionals developing a 20 megawatt hydro project, end quote. The reference to the 20 megawatt hydro project is to the Mamacocha project, correct?
That is correct.
The next sentence says, open quote, the total investment is 70 million and financing has been secured through a combination of US and Canadian investors and debt financing from DEG and a consortia of European development banks. Is that accurate?
It was accurate at the time. We had, the US investors, our sponsors. We had Interjex, the Canadian investor. We secured the debt financing from DEG, and they were going to use a consortia of European development banks. So that was the setup.
I just asked you a couple of seconds ago if the Mamacocha project secured financing, and your answer was it would have, but it didn't. So I ask you again, the description of the status of the Mamacocha project in your CV, do you still believe it's accurate?
Well, I guess I should have changed some of the wording. Again, when this CV, when I provided that, obviously we knew that the Mamacocha project wouldn't move forward. That's correct.
In your first witness statement, you explained that in December 2011, your team at Gray Invest came up with the plan to build a run-of-the-river hydroelectric plant that used part of the Mamacocha lagoon to generate electricity, correct?
It was used the overspill from the Mamacocha lagoon to generate electricity.
And as part of this process, Gray Invest commissioned S.R.L Ingenieros to do a pre-feasibility study, correct?
Correct.
The pre-feasibility study focused on the hydrological, geological, archaeological, topographical, environmental, and social conditions of the area surrounding the Mamacocha lagoon. Is that accurate?
That's accurate.
S.R.L Ingenieros delivered its final pre-feasibility report on 26 October 2012.
Correct.
In paragraphs 25 to 28 of your first witness statement, you described S.R.L Ingenieros' findings with great specificity. Did you append that study to your witness statement?
I am not sure if it was appended or not. No, I don't think we did that.
But you must know the document fairly well because you described its contents in your witness statement at length, correct?
That's correct.
Claimant submitted S.R.L Ingenieros' pre-feasibility report along with the memorial as exhibits C100A through E. I will now ask that exhibit C100A be put up on the screen where you will see the cover page of the report. Could you please confirm that this is the document you are referring to in paragraphs 25 through 28 of your first witness statement?
Can I have a look at the date of that document, please?
Yes, scroll down.
That seems to be the correct document.
You indicated in paragraph 30 of your first witness statement that based on the positive results of the pre-feasibility report, the team at Gray Invest decided to create CHM, which is the company that was formerly known as Hidroeléctrica Laguna Azul.
That's correct.
CHM is one of the claimants in this arbitration.
Yes.
CHM, then called Hidroeléctrica Laguna Azul, is the company that bid for and was eventually awarded the rare contract for the Mamacocha project, correct?
It's correct.
Okay, let's pull C100A back up again. Exhibit C100A contains the pre-feasibility report's executive summary. Let me direct you to PDF page 13. Under number 3, you can find the subsection titled Conclusiones y Recomendaciones, or Conclusions and Recommendations in English. Do you see that?
I do.
Let's scroll down to page 14. On the next page, S.R.L Ingenieros highlights its main 3 conclusions, identified as A, B, and C. Do you see that?
I can see B and C. I can't really see A, but if you scroll up.
I'm so sorry to interrupt, Mr. President and members of the tribunal. I believe Mr. Sillens testified he does not speak Spanish, so I'm not sure.
Mr. Molina, I thought there was also an English version of this report, isn't it? I remember this page.
I'm not aware of one. I do not believe.
And I read it, but then I saw, in my mind, I saw that I read English, but it turns out to be Spanish. Okay, fine. Right, but then slowly, Mr. Veras, if you point the witness to any text, I would suggest that you first give a translation under the supervision or the control of Mr. Molina.
Thank you, Mr. President. I will, and I will also remind Mr. Molina that Mr. Sillen already testified that he is intimately familiar with this document.
But he doesn't speak Spanish. He testified earlier.
Yeah. So let me continue. So I want to, let's go to conclusion B and highlight that. Conclusion B states, and I will translate, hopefully I will not get anything wrong, but I'm sure I will be corrected if I do. It states, quote, "The construction stage of the plant is the most sensitive part of the project. So the possible impact to the people of Ajo and the environment must be managed with many precautions." Therefore, Mr. Sillen, at the time Grainvest decided to create CHM in 2012 and to move forward with its investment in Peru, it had already been warned that the environmental impact of the plant could be an issue. Is that accurate?
Well, as always during construction, there are, you have to take environmental precautions. I mean, you're moving big vehicles, you are, excavating tunnels, using explosives. Of course, you have to take care.
So at the time that you decided to invest in Peru, you were aware of potential environmental issues to consider.
Not, we didn't have, specific issues that we had to consider. I mean, we knew that, of course, as a, diligent and respectful developer, you always have to take care of the environment.
And it was one of the three main conclusions in the pre-feasibility report that many precautions had to be taken in this case with regard to the construction phase of the Mamacocha project, correct?
As always, in any type of civil works construction, you have to do that.
Okay, you could pull down the exhibit. Thank you. In 2011, the Grainvest team selected the Mamacocha Lagoon as the location where the Mamacocha project was to be built, correct?
That's correct.
And after CHM was created in late 2012, CHM hired Piori, is that how you pronounce it?
Piori,
thank you, to finalize the design for the Mamacocha project, correct?
That's correct.
When Minem published the terms of the third auction under the Rare Promotion Program in late 2013, CHM submitted a bid for the Mamacocha project, correct?
Yes, that's correct.
And to participate in the auction, prospective concessionaires had to submit numerous documents containing information about the characteristics of the project, correct?
It wasn't too much of the, characteristics of the project. Essentially, what was being requested was a price, the amount of energy, and that was essentially, primarily what they were looking for, including, a bid bond at the time. I think it was $50,000 to participate in the tender, but it wasn't, we didn't have to submit a feasibility study. We didn't have to submit any of the permits that that we were, trying to get at the time.
Would you have had to submit specifics in regard to the location of the project?
Yes, I believe that was one of the requirements.
Would you have had to submit general information or specific information about the concept and design of the project you were submitted?
I believe we had to submit some design information on the project. We had to submit specifically where we intended to connect the project to the electricity grid. So there were certain, characteristics, but I wouldn't necessarily call it that we had to submit a lot of documentation.
And this is because the auctions related to the rear promotion, in the auctions related to the rear promotion program, each prospective concessionaire was responsible for the design of their own project and determining the feasibility of their own project, correct?
Yes, that's correct.
In December 2013, MINEM announced that CHM was one of the 19 successful bidders in the third public auction, correct?
That's correct.
CHM and MINEM executed the WARE contract on 18 February 2014.
That's correct.
The WARE contract is in the record as Exhibit C0002. I will project claimant's English translation of the WARE contract. And we'll turn to Article 4.6. Article 4.6 of the WARE contract. According to Article 4.6 of the WARE contract, the concessionaire shall submit a work schedule to OCINERMIN within 6 months of the closing date, correct?
That's correct.
And such work schedule shall include deadlines for certain specified milestones. Is that correct?
That is correct.
CHM submitted its proposed work schedule on 18 August 2014, correct?
That's correct.
CHM's 18 August 2014 work schedule set forth the dates in which CHM expected it would be able to complete each project milestone, correct?
I believe it did, yeah.
You refer to the work schedule in your first witness statement at length, Mr. Sillen.
I refer to it, yes, correct.
I would like to pull up your first witness statement. In paragraph 61, you explain that in addition to the commercial operations date, the execution work schedule included various milestones that CHM had to meet to demonstrate that the project was on track to achieve commercial operation by the contractual deadline, including a financial close milestone. Is that correct?
That is correct. This was an information we had to provide to OCINERMIN. At the time, we were in discussions actually with OCINERMIN about it. So yes.
And then for paragraph 62, you go on to say that CHM never planned to finance the Mamacocha project by itself. And it also states that to achieve financial close, CHM had to secure equity capital and loans for the project. Is that correct?
That is correct, yes.
And then in paragraph 63, you say that it would not be possible to close on financing if you didn't have the permits in place. And then for the sake of clarity, when you say we in paragraph 63, you mean CHM, correct?
Correct.
You can take down the exhibit. The work schedule CHM submitted to OCINERMIN on 18 August 2014 had a financial closing milestone of 1 November 2014, correct?
Yes, but we also had discussions with OCINERMIN and we were in the process of, getting it updated.
When you submitted in 18 August 2014, you established the deadlines for the financial closing milestone, right?
And those were, the ones that we had previously targeted, but we also knew that we had, permitting delays. So we engaged with OCINERMIN over September through November to rectify that. In August, we hadn't had, the opportunity because we were still, at that time, waiting for the environmental permit.
Okay, so on August 18, 2014, the date when CHM submitted its original work schedule, the Mamacocha projects did not have environmental permits, correct?
That's correct.
And then on August 18, 2014, the Mamacocha project did not have its final concessions, correct?
Correct.
And on 18 August 2014, the Mamacocha project had not secured equity capital and loans to finance the project, correct?
We were in discussions, but we hadn't secured it.
And still, the financial closing milestone communicated to Orsinermin on 18 August 2014 was the 1st of November of 2014, correct?
As I said, we were in discussions with Orsinermin. We submitted something that was, our original work schedule. Orsinermin worked with us over the time. They advised us, to move the dates, which we did. And that's when, in November, we decided to submit a request for moving the dates in works execution schedule.
So when you submitted your original works execution schedule, you were aware that you would not be able to comply with that works execution schedule?
I don't understand the question. Can you repeat that again, please?
I am asking you if you are telling me that when you submitted the works execution schedule in 18 August 2014, you already knew you would not be able to comply with the dates you set out in that work execution schedule.
Yes, and Orsinermin, they were aware of that as well.
In paragraph 76 of your first witness statement, you state that the Mamacocha project required additional investments of approximately 60 million.
We'll get to that paragraph. So that refers back to the construction phase?
Yes.
Yes.
So, however, you explained that CHM investors had not planned to finance the construction operation phases of the project by themselves, correct?
I'm sorry, can you repeat that?
So my first question was, did the Mamacocha project require additional investments of approximately 60 million?
Yes.
And my second question was that if it is correct that you explained that CHM's investors had not planned to finance the construction and operation phases of the project by themselves.
That is correct, yes.
Your plan was to secure close to 20 million from third-party equity investors and obtain a project finance loan for more than $40 million. Is that correct?
That's correct.
As of March 2017, you were in negotiations with DEG to finance the Mamacocha project, correct?
Which date did you state? I didn't hear that.
As of March 2017.
Yes, yes.
And as of March 2017, you were in negotiations with Energex to finance the Mamacocha project, correct?
well progressed, yes.
I will pull up Exhibit C 163 on the screen. You described this document as the contemporaneous timeline created by Latam Hydro and approved by Interjex and DEG that sets out the dates relevant to the negotiations. Is that correct? That's
Yes.
in paragraph, oh, pardon, go ahead.
Those were the timelines that we shared between parties.
If we can have the attachments open, please. The attachment is the actual Excel spreadsheet of the timeline.
If I may maybe help you out on this one, because I had the same problem like you, that the attachment is not included in that, or I couldn't open it at least. Oh, there we go.
Thank you, but we seemingly worked it out. Based on such timeline, you expected to sign the Interjex contract by January 2017, correct?
We expected to have, if you move, go down.
Can you scroll down? Yes. Scroll down. Interjex, thank you. And where it says signing.
Yes, that was the intention to have at least an agreement in principle on the main documents and terms, and then could potentially work with that for a longer time.
However, as of 13 March 2017, the partnership agreement with Interjex had not been signed, correct?
No, but soon after we agreed with Interjex in principle again, on the budget. But that's correct in that. We had a meeting in Montreal, actually. We didn't get to sign the contract, but as I said, we agreed in principle. There was still, some details to be taken care of.
So by March 13, 2017, you had not signed the partnership agreement with Interjex?
No, because as I said, we had an agreement in principle. They had, agreed on signing to put down, $400,000, I think was the amount, to help with the financing to bring, all the permits and up to financial closing.
I can't see in the record if the answer to my question has been recorded, because you were mentioning a $400,000 payment. But my question was, as of 13 March 2017, was the partnership agreement signed?
We hadn't signed at that time, correct?
You had not signed at that time?
We didn't. We hadn't signed the partnership agreement. We had a letter of intent and we had an agreement in principle, but we didn't have the final document signed.
Thank you. Just wanted to make the transcript clear.
Is it on your transcript? Because if I saw it on mine, I don't know if yours froze.
I only have the Spanish up, so that's why I couldn't.
Oh,
find
that's
it.
why. Sorry.
In your in your witness statement, you state that you expected to finalize negotiations of the loan agreement and close the loan transaction in mid-May 2017. Is that correct?
That's correct.
And in early 2017, DEG sent an updated list of conditions for the loan, right?
Well, this was I think I know which document you're referring to, and that was a document where we noted down issues that were, being discussed between the parties to be as clear as possible, what to expect. Some of them were hard conditions. Some of them were, soft conditions, and not really, related to whether or not to provide financing.
And will you please pull up the first witness statement, paragraph 116. I'm going to read it. Paragraph 116 of the first S.R.L witness statement. Open quote. We were also confident that we would soon close on the loan with DEG. In January 2017, DEG sent us a spreadsheet that detailed its preconditions for credit approval, for closing the loan, and for first disbursement. Could you tell me where in that paragraph you explained that these conditions were subject to discussion, were not firm?
Well, the conditions are not firm until you have them in an actual, term sheet. As I said, this was something, that we shared with the bank, or they shared with us. We added to it. It was, to memorialize the discussions that we had ongoing. Basically, it was a document to make sure that we understood each other and that we understood what the bank required from us in terms of, going through the steps of credit approval up to signing and then to disbursement. But as I said, it's a document.
It's a document that memorialized what the bank would require from you to move forward in each of the steps of credit approval, signing, and disbursement. Did I understand that correctly?
On most of them, there was some that that we had, addressed with the bank, and so it was also a document, to follow up on issues, and it certainly wasn't, a document that couldn't be changed.
Is there anything in the record that reflects that DEG had that same understanding?
I don't know. I don't know exactly what's in the records.
May please turn to C162 on the screen. This document includes conditions for signing and for disbursement, correct?
Credit signing disbursement.
And financial close, as defined in the RARE contract, was tied not to signing, but to disbursement, right?
In the contract, yes.
Can you go back to 162, please? One of the conditions in C-162 is the financing partner, correct? The very last line of the conditions table.
Financing partner, yes.
This was going to be a requirement either for signing or for disbursement, correct? But the financing partner had agreed to the loan, correct?
It was essentially, something that that DG took care of. They had, a syndication with other European development banks like the Dutch Development Bank, FMO, Austrian development banks. I guess there were, a few of them.
And the inclusion of a financing partner is sometimes also referred to as syndication of the loan, correct?
That's correct.
And the financing partner would also review the term sheet, correct?
Yes, and the way it works, is it's like a club. Normally, when one of the banks they bring in someone else, they rely on the due diligence that has been done by the lead bank. They rely on the credit committee. They rely on the lead bank to have done its due diligence. It might require, not always, but quite commonly, an additional credit committee at the syndicated bank.
Yes, in fact, if we can pull up C-163, please. Row 82, that's indication, see? Can we highlight that? Can we scroll? So your timeline for the loan actually considered that the financing partner had a credit approval process and that would take time, correct?
That's correct. At that time, this was our understanding of it. We were, having close meetings with DG. We knew that they were progressing on it. We understood that there would be a credit approval, but that, the syndicated banks would rely on DG's due diligence and negotiation.
In this timeline, it states that you expected the financing partner's credit approval process to take at least a week, correct?
I think I put it for a week. Yes, that looks like it.
And this process was supposed to be completed by March 10, 2017, correct? That's what the timeline envisioned.
That's true. This, and if you can scroll up a little bit, just so I can see, the credit approval by DG, because I'm pretty sure you're going to go there as well. So we had the approval sometime mid-February for the credit committee, and that was what we were aiming for. In our negotiations, which Ingex was involved in, we decided, to get clarity on, the term sheets, and so It was in well developed. We had no reason to believe that we couldn't get the approval from the bank.
By March 10th, 2017, pardon. Going back to the timeline, the process for the credit approval, according to the timeline, was supposed to be completed by March 10th, right? That's where we left off.
That's correct.
Under the parties' timeline, it would take about 2 months from the credit approval for the financing partner until the close of the loan, right?
That was provided, if we had any conditions that we needed to close in that time, and this is for signing.
You testified that based on DEG's assertions at the time, you believe the process of bringing in syndication partners would not have impacted your ability to achieve financial close by May 2017. This is in your second witness statement. Is that correct?
That is correct.
But by March 6, 2017, DEG had not even selected their financing partner, correct?
Not finally selected, but we knew that they had a lot of interest. And as I said, this is a very conventional setup where they participate in each other's engagement, so to speak.
No financing partner had been selected by March 6, 2017, correct?
Well, I think I responded to that question.
Another condition precedent to closing was the extension of the PPA, correct?
It wasn't a proper, it wasn't a condition. It didn't really have any impact on what was a condition was that we had the COD date extended, which we, by the way, got on January 3rd. The extension to the termination date was simply a way for us, to see if we could extend the tenor of the loan. It didn't have any impact on whether the bank would provide us with a loan or not. The bank is not interested in the product's profitability. The bank is interested in us being able to make the repayments on the loan during the tenor. And if we could extend...
Pardon, go ahead.
If we could extend the tenor, that would be good for us. The bank didn't really care in that respect.
Can we please pull up 162 again? So it says DEG conditions, PPA extension, credit, positive indication that PPA extension will be considered, resolution process is about to start. Signing, indication of positive resolution process. Disbursement, PPA extended. Do you see any indication in this list that this was not really necessary?
Well, I know the discussions from the time. As I said, the term date of the PPA simply didn't have any impact on DEG's appetite to finance the loan. It was important to us because with the delays that we had experienced, we only had a 17-year PPA. Obviously, we wanted to, reinstate that so that we could get a longer loan tenor, because a longer loan tenor means that we can have a higher debt because it's all controlled by the debt service coverage ratio. And if we get more debt, less equity is required. Less equity required, higher leverage on the project, but it didn't have any impact on the bank's appetite to close the loan, which we also, by the way, showed in the financial model that we provided to DEG, the so-called injects model.
Mr. President, can I have a 2-minute break to consult with my team as to if we're going to stop today?
By all means. We're also available, if you want to continue, you have heard the claimants are available, and the tribunal is also available. So if you want to do that. But okay, take your 2 minutes.
Thank you. Can we go into the breakout rooms?
Yeah, sure, by all means.
Thank
But I
you.
think then I should take a recess of 5 minutes.
Yes, that's fine. Thank you.
Is that what you're asking? Okay, good. 5 minutes. Yeah. Can you see me, Mr. Veras? Well, you are disappeared in a very small corner of my screen. That's not the idea. But also, so is also Mr. S.R.L. So the let's see, gallery. Wait, this is better. Okay, all right. Well, Ms. Taberas, what is the result of your internal consultations?
Mr. President, I think we're ready to pass the witness. I think I'm done with my interrogation.
Thank you, Mr. Veras. But then I turn to Mr. Molinas.
Thank you, Mr. President. I'm going to have to do my zoom in thing again. There you go.
You are on the steep learning curve.
Exactly.
Mr. Molina, are you ready for a redirect?
Yes, we are, Mr. President. Thank you.
And how many minutes do you estimate?
We have until today, remind me, we have until 9:30 CET time, Mr. President.
Yeah, but okay, but I minded to go longer, but I thought in light of the Ms. Tavera's shorter cross-examination that estimated that your redirect also would be shorter.
That's fine. Mr. President, that's my expectation as well.
Yeah, your hands, so you tell us.
Yeah, that's my expectation as well. I believe this will be shorter than anticipated.
All right. Okay, let's go.
Okay. Mr. S.R.L, good afternoon. You were just shown the document titled DEG conditions. Do you mind putting up C-162 on the screen again, please? Mr. S.R.L, you remember being asked about this document? Oh, I think your mic is muted.
My apologies. Yes, I do.
Okay. Remind me again, you sent this document, or you received this document in January of 2017, is that right?
I believe it could have been January, yes, correct.
You've confirmed, Mr. S.R.L, that by March 14, 2017, the PPA had not been extended. Is that fair to say?
Well, as I tried to explain, it hadn't been extended, but it was not a requirement as such.
But by March 2017, DG had paid for due diligence, legal due diligence. Is that fair?
All those costs, were assumed by us. I mean, that was pass-through cost, but they had invested significant of their own time, in traveling to the site, in participating in meetings, in facilitating meeting with us in Cologne. I don't know how many times, but yes.
Would they have done all of that if it was necessary for them for the PPA to be extended?
No, they wouldn't have spent any time on us. I mean, it's a bank. They're professionals. They wouldn't have asked us to do something that, wouldn't mean any difference to them in reality, which is, shown by the Interjex model, which we shared with the bank. We never in that Interjex model anticipated that we would get an extension of the term date of the PPA.
Mr. Sellin, you were asked about the first work schedule by Mr. Chavez. Do you remember that?
I do.
And what was the result? And you mentioned that there had been there was an extension request shortly after that first work schedule was sent. There was a request for an extension by Mamacocha. Is that right?
That's correct.
And what was the result of that request?
Well, we had, I think, calculated the delays that had occurred to the project up to that date to 705 days. That was, what we were requesting. The Ministry of Energy and Mines, also in the MIN, they spent, 6 months reviewing it, doing their own analysis. They came up with a higher number. I can't remember, but it was significantly higher. But they also only gave us, the 705, which is, what we asked for.
So is your understanding that there were independent levels of review to the application for extension that you submitted?
Both at Ministry of Energy and Mines and at also in the MIN.
Mr. President. Excuse me.
Yep.
Some of the questions being asked are extremely leading. I object to having leading questions presented to claimant's own witness by claimant's attorney. So I would ask that the tribunal interfere if it deems appropriate.
Okay, sustained, Mr. Molina, could you not be unreasonably leading?
Absolutely, Mr. President. I think that with this, we're done. Thank you.
I look to my colleagues. Mr. President Venuesa?
No, I have no questions.
President Tawil?
No, Arborian, I have no questions. Thanks.
Okay, I have one small question on page 12 of your report.
Of my first witness statement or second?
Your first.
Okay.
There you have it. Yeah, you have it in front of you, and maybe it can also be shown on the screen. Page 12. There is an image of a Laguna Mamacocha.
Yes.
Right. See that? So so you see there the Laguna. This is which is where the otters are. That is still on upstream, isn't it?
That's correct. There was a small number of otters in that area.
And shrimps.
Not in the lagoon.
Oh, okay. Where was the shrimp?
That's in the Colca River, in the confluence, with the Mamacocha. The Mamacocha River and the lagoon is very, very clean. It doesn't have nutrients enough to sustain, and certainly not the habitat for the shrimp.
Okay. Now the intake is toma. Huh? Is the toma maybe your first lesson in Spanish?
I can understand toma.
Okay, great. There's the intake, and then you have the canal. And you have the tunnel. It's a head race tunnel.
Correct.
And about the tunnel, Was lining necessary for the tunnel?
I'm sorry, can you repeat that?
Was a lining necessary for the tunnel?
Yes, there's lining, concrete.
Yeah, and concrete. How much lining and how much concrete?
Oh, I don't have those numbers exactly. No,
because do you know the composition of the stones?
Of the rock quality, you mean?
Yes, exactly.
Well, we did substantial geotechnical investigations in the area. We were drilling 100 meters into the mountain. What we found in those investigations was, that yes, there's some porous rock at the first stretch, but the longer in you got into the mountain, the more solid it was, and even more importantly, there were no water infiltration, which obviously is a concern when you're building something, a structure.
Are you familiar with other projects in Latin America about these type of tunnels? Hydroelectric projects?
If I'm familiar with other projects in Latin America, was that your question?
Yeah, that was my question. About this type of these head-raised tunnels.
Some of them, yes.
They have problems with leaks.
They can have problems with leaks, yes, correct.
One question I have further on this slide is, if you look from the intake, so you go to canal, but is there still free water flowing? Because there's another picture I saw in the file. It said that it became dry, seco. It said.
No, we always, and this is by the laws in Peru, the regulation requires you to always have what is called an ecological flow.
Exactly. Okay. Talking about this, can you go to paragraph 99 of your first witness report? So you talk here about the environmental concerns. What type of concerns were expressed?
The otter was one of the concerns, that this was a habitat for the otter. What we understand from the experts that were advising us was that it was not a permanent habitat, but because it's also a very steep region to get, their natural habitat is in the Colca River. So that's one of the concerns. The other one was that we would dry the lagoon, that we essentially the levels of the lagoon would disappear. There were concerns about the shrimps, which, as I explained, did not live in the lagoon. They had concerns about the shrimps, or that the water in the turbines would somehow, do something to the water that would affect the shrimp fishing in the Colca River. There were, as far as we understand, there were no technical reports or anything in the findings in our technical reports that showed, that it would have had a considerable environmental impact.
Have you visited the site?
I have been to the site several times, yes.
Would you describe it as a natural wonder?
The lagoon is very beautiful, yes.
Thank you. I have no further questions. Any follow-up questions?
Albert, can I have a question prior to council?
Sure.
On a different matter, Mr. Selin, there have been allegations about the division of the project between the grid and the plant for the environmental authorizations. Could you develop a little bit what was the rationale? Why did you did that separately, and how did that work?
Yes. So
maybe I may a little bit give a little detail here. So originally it was a category 3, and then what we heard yesterday was the argument. Yes, it was split between a permit for a tunnel and one for the transmission line, so that it could then become a category 1 authorization project. So what is that's the question, or is it not what you have?
No, I'm not sure it was that way. It was for the plant and for the grid more than for the tunnel only. And I want to understand, why did the company separate the two projects, or I mean, what was the rationale and how that did work with the authorities, etc.? Why did that happen?
Yes. So,
but sorry, but Alberian, please, if you want to complete, of course.
No. What I meant by tunnel is the same as what you meant by plant, but okay, plant is more accurate. I agree.
Okay.
Okay. So the transmission line is, or was supposed to be, a little bit more than 60 kilometers long. It goes, a long way through certain parts of, not outside of Fire. It goes over, Andawa, goes through Chilcamarca before it connects at the Chipmo substation. We had already then, with Peru, realized that there was a possibility to, upstream of the project, build a cascade of small hydros between 9, 12, maybe up to 15, megawatts that could use the same transmission line. And that was one of the reasons why we, or that was, the significant reason. And we also, by the way, that we decided to divide it and have, a separate environmental impact assessment for the transmission line. And it was also designed, for a much larger transmission volume than could be sustained by the Mamacocha project. That was the main reason. So, and again, I hope I answered your question. I know, Mr. President, you had a slightly different angle to it.
No, that's not my angle, but it was the angle I heard yesterday by argument. So that was also, and that raised for us questions, and we thought we can explore it with the witnesses. But now I have heard the answer. Guido, anything further?
No, not really. I just wanted to know the rationale and what was discussed at that time. But I mean, if that's what Mr. Sinan has to say, that's fine.
Raul, anything further?
No.
Thank you. I look to Mr. Molina. Any follow-up questions?
Thank you, Mr. President. I think it might be useful, and I think for Professor Tawil's, and furtherance of Professor Tawil's question, it might be useful to pull up C229.
Right, so you have a question?
Yes, the question is if this, if the analysis on page 53, at the bottom of page 53 and top of page 54 comports with Mr. Sillen's understanding of this, of why the transmission line was separate from the plant.
Excuse me, Mr. President, I'm sorry. Again, Mr. Molina is trying to testify on behalf of the witness. This should not be allowed.
This leading, can you do that in argument?
Yeah,
Molina?
That's perfectly fine.
Have you any question?
Other than that, no questions.
Mr. Veras?
No follow-up, thank you.
Okay, thank you. All right. Okay, then, Mr. Sillen, thank you for testifying. You're excused as a witness now.
Thank you, Mr. President. Thanks to the tribunal.
Thank you. All right. I look now to counsel, because we have made progress. We are 1 hour in advance for tomorrow. And so we can start immediately with the Mezzano, Imodes Mezzano. And I invite the parties, the council to consult with each other, whether we can have now an update of the schedule.
Sorry.
Yeah, okay, Mr. Gane, please.
I was going to say, Mr. President, that I believe we are on schedule, and we can start with Francisco Ismodes, as you indicate. And in fact, it seems that we are ahead of schedule.
Exactly the question I submit to you. So, Mr. Gane, if you can talk with Mr. Rijzenveld or people of your team, with the team of Mr. Rijzenveld, to update the agenda as you've sent to us. Because we had a schedule, we are almost, let's see where we are now, where we would have started tomorrow at 5:30. So that's 2.5 hours we had making progress. Okay, if I may invite the parties to do that, would be wonderful.
Yes, we'll be happy to do that.
Okay, Mr. Rijzenveld, anything further for today on procedural matters, household?
No, thank you very much.
Okay. Let's see, Mr. Gane, anything from your side?
Nothing from our side, thank you.
Okay, and I wish you all a good evening and see each other tomorrow at 3 o'clock.
Thank you.